Hey, this is Tom. Can you guys hear me?
Yes, I can see and hear you.
Thank you. And good morning to all on this snowy day down in downtown Denver.
To you, Tom.
Good morning. We're now on the record. It's 9 a.m. on November 7th, 2024. This is an evidentiary hearing in proceeding number 21A-0141E, Public Service Electric Resource Plan and Clean Energy Plan proceeding regarding the sub-issue of the proposed Clean Energy Plan delivery motion. Eric Blank, the chair of the commission. Can my colleagues introduce themselves for the record?
Good morning, Commissioner Tom Plant.
Commissioner Megan Gilman.
Thank you. Let's keep going with entries of appearance, starting with public service.
Good morning, Mr. Chair, Commissioners. Matthew Larson, Wilkinson Barker Nauer, LLP, on behalf of Public Service Company of Colorado. I'd also like to enter the appearance of Christopher Irby on behalf of Public Service.
Thank you. City and County of Denver.
Good morning, Mandy MacDonald from the Denver City Attorney's Office on behalf of the City and County of Denver.
Thank you. City of Pueblo and the Pueblo Board of Waterworks. Colorado Energy Office.
Morning, Commissioners. First Assistant Attorney General Jessica Lowry, representing the Colorado Energy Office.
Thank you. Colorado Office of Just Transition.
Good morning, Commissioner. Heather Whitman from the Colorado Attorney General's Office, and I'm here on behalf of the Office of Just Transition.
Thank you. Colorado Oil and Gas Association. COSA.
Good morning, Commissioners. Jake Schlesinger with the law firm Keys and Fox on behalf of Colorado Solar and Storage Association and the Solar Energy Industries Association. Mike Kruger, who submitted testimony in this round of this proceeding, is also with me today.
Thank you. Holy Cross Electric Association. International Brotherhood of Electric Workers. Pueblo County.
Good morning, Commissioners. Francis Consiglio on behalf of the county, and since we are not presenting testimony or cross-examining anyone, I would like to be excused from the rest of the hearing.
So excused.
Thank you.
Thank you. Rocky Mountain Environmental Labor Coalition and Colorado Building and Construction Trades Council. Trial staff.
Good morning, Mr. Chairman, Commissioners. My name is Paul Kite. I'm a First Assistant Attorney General appearing on behalf of trial staff, and my co-counsel will introduce herself now.
Good morning, Mr. Chairman and Commissioners. Aileen Chong with the Colorado Attorney General's Office, also here on behalf of PUC trial staff.
Welcome. Utility Consumer Advocate.
Good morning, Mr. Chairman, Commissioners, and all parties. Tom Dixon, a First Assistant Attorney General, appearing on behalf of the Attorney General's Office in one of our capacities on behalf of the Utility Consumer Advocate.
Thank you. Walmart Inc. Western Resource Advocates.
Good morning, Commissioners and parties. Parks Barroso representing Western Resource Advocates.
Conservation Coalition.
Good morning, Commissioners. Matt Gerhardt on behalf of the Conservation Coalition.
Thank you. Interwest Energy Alliance.
Good morning, Commissioners. Chris Leger representing the Interwest Energy Alliance.
Onward Energy Management.
Good morning, Sarah Keene of the law firm Kathleen Kirsch on behalf of Onward Energy. However, Onward would request to be excused as it is not taking positions on anything in this hearing today.
So excused. Thank you. Colorado Independent Energy Association.
Good morning, Mr. Chairman, Commissioners. Mark Detsky of the law firm Dietz and Davis, entering my appearance on behalf of the Colorado Independent Energy Association, or CIA, and I'd also like to enter the appearance of Daniel Rubin. Thank you.
Thank you. Intermountain Rural Electric Association, I guess Core Electric Co-op. Vote Solar.
Good morning, Michael Hyatt with Earth Justice, appearing on behalf of Vote Solar. Vote Solar would also like to request permission to be excused.
So excused. Thank you. City of Boulder. Colorado Renewable Energy Society. Climax Molybdenum. Mr. Fanyo.
It's easy for you to say.
Yeah.
Richard Fanyo on behalf of Climax Molybdenum Company.
Now you're just showing off. Colorado Energy Consumers.
Good morning, Commissioners. Austin Rushoff with the law firm Holland and Hart on behalf of Colorado Energy Consumers, or CEC.
Thank you. That concludes my list. Finally, Commission Counsel.
Yes, Erin McLaughlin, Commission Counsel and Chair. There was one late intervener as well that I believe will be entering their appearance today.
Mainspring.
Thank you, Ms. McLaughlin, and thank you, Commissioners. And hello again, Sarah Keene of the law firm Kaplan Kirsch on behalf of Mainspring Energy, also entering the appearance of my colleague Sarah Judkins of Kaplan Kirsch and Havan Goydam, internal legal at Mainspring. Thank you.
Thank you.
Commissioner Blank.
Yes.
Hello, it's Heather Whitman again. I neglected to ask you if I could be excused also today. We won't be participating, and apologies for interrupting.
Yeah, no worries. So excused.
Thank you.
Ms. McDonald.
I'm going to ditto that. I apologize when I entered my appearance, did not likewise ask, but we did not file any testimony for Denver and have no cross-examination.
So excused.
Thank
Thanks
you,
for
Chair.
letting us know. Anybody else who'd like to enter an appearance or an excusal? All right. We're going to conduct this hearing using electronic exhibits. A spreadsheet marked as hearing exhibit 2904 lists the latest versions of the pre-filed testimony and attachments. With that, any objection to the omission of hearing exhibit 2904, the spreadsheet listing all of the exhibits?
Mr. Chair, on behalf of Public Service, no objection to the omission of hearing exhibit 2904. I'm not aware that there's any objection from any of the other parties. We do have a couple of discovery stipulations that will modify the cross matrix, but we can take that in due course at appropriate time.
Yeah, if we could get 2904 and all the hearing exhibits admitted first, that'd be great. Mr. Detsky, any objection to 2904?
No objection, Your Honor. Just a question for clarification. I noticed that for parties like CIA who filed comments were not listed on the 2904, and just wanted to know if just refer to them as CIA comments without a hearing exhibit number, but clarification that they're on the record as well as the attachments.
I think, yeah, I'll turn it to counsel in a second, but yeah, I just refer to them as the CIEA comments, and I've certainly read them. So, Ms. McLaughlin, you all right with that approach?
Yes, certainly. They are in the record, but today for witnesses' testimony is what we'll be focused on, of course.
Yeah. All right. Any objections to 2904? With that, hearing exhibit 2904 is admitted. I'd like to admit all the items listed on hearing exhibit 2904. Is there a stipulation among the parties or any objection to admitting these documents subject to the future discussion of discovery stipulations as outlined by Mr. Larson?
And no objection from the company, Mr. Chair.
Okay. Anyone else? All the pre-filed exhibits listed on hearing exhibit 2904 are admitted. Other preliminary matters, Mr. Larson.
Yeah, thank you. Costa Cia and the company have reached an agreement on the stipulation of what I believe has been marked in Costa Cia's box as hearing exhibit 2204, which is a series of discovery responses, and Mr. Schlesinger can chime in as well. But with that stipulation, I believe they're prepared to waive cross-examination of the company's panel.
Costa Cia, any comments?
No, well, sure. The discovery responses are basically on the issue of PPA negotiations. And, I guess we would just move for the admission of exhibit 2204 in lieu of cross-examination.
Any objections?
No objection from the company.
So moved.
Thank you. Your Honor, may I inquire at this point in time whether the commission plans to call Mr. Kruger for any cross-examination? He's currently not listed for any cross-examination by parties on the matrix.
I do have a couple questions for him, and I'll just let you know what they are. In his testimony, he expresses concerns about the status of the negotiations. I'd like to ask him to better understand what the outstanding issues are, if any. So, but I don't know that Mr. Kruger has to listen to the prior hearing to answer those questions. And I'll ask my colleagues if they have questions. Commissioner Plant, questions for Mr. Kruger?
I have one question kind of along similar lines, yeah.
Commissioner Gilman?
I don't have any plans, but they've got me curious on what's in hearing exhibit 2204, so interested to see.
So with Commission Counsel, any questions for Mr. Kruger?
No questions from council or advisors. Thank you.
So, Mr. Kruger, if you could be available at the right time, and I think we've given you a heads up about what we'll be asking.
Thank you, Mr. Chair and Commissioners.
Yep. Was there one other witness who we can excuse? Oh, Ms. Durkee, Ms. Lowry.
That's exactly what I was going to ask.
You're echoing, but I do not have questions for Ms. Durkee. Do you, Commissioner Plant?
I do not.
Commissioner Gilman?
No.
Commission Counsel?
No questions. Thank you.
I think Ms. Durkee can be excused, Ms. Lowry. Thank you.
Thank you.
Any other preliminary matters? Mr. Larson?
We also have one with staff. Mr. Kai, do you want to start on that, and I can come in behind you?
Yeah, thank you, Mr. Larson. Mr. Chair, Commissioners, have a number of stipulations to discovery from the company that I think will help expedite things here today. The first one I have is hearing exhibit 2710 HC. Now, this is a highly confidential exhibit. That is the work paper associated with the L&R table on table 1 of page 27 of hearing exhibit 166, attachments JWI-19. And the company has agreed to stipulate to admission in the record of 2710 HC.
Okay. Other stipulations, or is that it?
Yeah, I have more. Yeah. So that's the first one. The second one is a series of exhibits. It's hearing exhibit 2711, which has both a public and a highly confidential version. through hearing exhibit 2718. And what that is the company's response to a discovery request, as well as 7 attachments. And what that is that staff had asked the company for thermal projects to provide an updated executable revenue requirement, a comparison of the original as-bid revenue requirement to the currently requested revenue requirement, a breakdown of charges and equipment purchasing, breakdown of changes in major equipment, breakdown of changes in contracting schedule, breakdown of changes in contract pricing, and a detailed explanation of changes in labor costs. So that whole package, again, from 2711 through 2718 is that discovery response, which the company, I understand, stipulates to the admission of.
That's correct. The company stipulates to the admission.
Okay.
Thank you.
And one more.
Oh,
Yes.
Chair, I have a lot of questions about all this. Would you like me to wait until Mr. Kite has finished going through the list?
Yeah, and maybe council can clear them up off to the side, and you can report back, later this afternoon if there's still concerns. I wouldn't try and clarify an open hearing. So keep going,
Okay.
Mr. Knight.
Thank you, Mr. Chairman. And so the last stipulation we asked is a company discovery response CPUC 56-4, where staff asked the same questions for each company-owned wind project. So hearing exhibit 2719 has a public and highly confidential, and then there's a series of attachments all the way through hearing exhibit 2725, highly confidential. And the company, again, has indicated it would stipulate to admissibility of those.
Terrific. Anything else, Mr. Kine? Mr. Larson?
I believe CIEA also has a preliminary matter, and then I have one more with respect to the company's presentation of its direct case, and how that's going to follow
And
on.
I have other preliminary matters as well when we get to it.
All right. And is staff going to reduce its cross, or you still need 45 minutes?
Well, I don't think I'm going to need all of that. The stipulation was not to reduce the amount of time. It's just to
clarify.
Mr. Chairman, I will do my best to come in much quicker than 45 minutes. How about that?
All right. That's I'll take that.
Okay.
Mr. Detsky.
Thank you, Mr. Chair. As someone also with 45 minutes on the agenda, I wanted to make a clarification for the record based on the company's reply comments, where they had indicated that they didn't see a certain aspect of CIA's proposal. And I wanted to clarify for the record where that is in CIA's reply comments. I could do that on cross of Mr. Riley, but I thought it might be easier just to put it on the record here as a preliminary matter.
Do you think it's inappropriate to just notify council off to the side where it is?
I did do that as well, Your Honor. I talked to counsel for the company and communicated all this to him.
All right, so maybe there's no need to do it in public, or you're worried the record is still.
That's correct. There's still the record where public service is saying this is absent from CIA's comments, and I just want to point out that it's not absent.
All right, go ahead.
And that is in footnote 10, page 17 of CIA's comments, that we indicated that if the commission does not approve public services global PIM proposal for changes to its CEP projects, that CIA's counter proposal regarding stage 1 of component 1 would also apply to utility owned generation. And so that proposal was made in CIA's comments. Thank
Appreciate that. Mr. Larson, then back to you, Mr. Kine.
Mr. Kai, do you want to go first?
Mr. Larson, it's fine.
Yeah, my questions, Mr. Chair, are related to the company's presentation of its direct case using the panel approach. That is how we presented it in the cross-examination matrix. So I just wanted to talk through number one, if that's okay
Yeah,
with
why don't we do Mr. Kide first, if you would.
Sure.
Okay, thank you, Mr. Chairman. So the procedural order in this case did not specify whether the commission wishes to receive post-hearing statements of position. Now, traditionally in our proceedings, we wait till the end to talk about that, but I'm sure the company is anxious to proceed. I know the commission has a very busy schedule, so if you don't mind, I'd like to kind of take your temperature on what you're anticipating with respect to statements of position.
We were thinking November 18th, and if we got through the hearing early, November 15th. I think it's our goal to wrap this up as soon as humanly possible and provide guidance for a way forward.
And to that end, do we know how soon the transcript will be available if we're going to have a quick turnaround on that? Or can we expedite the transcripts, be my question.
Ms. McLaughlin?
I know we have an excellent reporter today, and we will aim to do that. I understand the expediency here.
Thank you. Thanks, Ms. Weisenthal. Does that give you what you need, Mr. Kide?
Yes, and I would second Ms. McLaughlin's comment that our court reporter is excellent. Thank you. Okay, so
Thanks,
that's
guys, I needed that.
Yeah, we'll stipulate to that, Harry. Harriet, any objections?
okay.
No objection.
And then I do have some more comments depending on what Mr. Larson says about how the panel's going to work. If you can come back to me with a few comments, that would be appreciated.
Okay. Mr. Larson, back to you.
Yeah, so Mr. Chair, I know it's a little bit unorthodox, but this is a unique proceeding. So we did propose in our cross matrix, as well as the notice of our cross-examination matrix, to present 5 company witnesses together. The way that we propose that would work is Mr. Eiley would be the primary witness. To the extent he had to defer a question to one of the other panelists, he would do that. And we could move through it with public cross-examination, highly confidential cross-examination, public commissioner questions, highly confidential commissioner questions, public redirect, highly confidential redirect, just to avoid switching back and forth between public and highly confidential session. So I just wanted to put that additional detail and see if that was an acceptable way to proceed.
I mean, I'll check with my colleagues, but personally, I love the panel because we don't have to chase issues among witnesses. And be careful what you ask for, Mr. Larson. The commission may like this in other proceedings.
Thought about
that. Commissioner Plant, any concerns with the panel approach?
No, I actually like that.
Commissioner Gilman.
No, I like the approach. So I guess as laid out by you, Mr. Larson, would have two discrete confidential kind of like breaks.
Yes, Commissioner Gilman, we were thinking there would be one for kind of each phase of the panel presentation. So one associated with cross-examination, one associated with commissioner questions, and then one to the extent my redirect went into any.
Oh, 3. Okay.
Information.
I mean, I don't have any problem with that, but I don't run the hearing. I know it's kind of a hassle to get into the confidential session. Yeah. So that's my only question, if that's like the most efficient way to do it. But I got no other problems aside the practicality of going into 3 different confidential sessions, not to mention the confidential sessions we might need with other witnesses. But
yeah, I'm not a big fan of that either. I guess I've tried to structure my questioning to avoid confidentiality. Okay. And at the end of it, at the end of the council cross, if something does come up, maybe I'll ask my questions then. Commissioner Gilman, do you have confidential questions?
You know, I have one that I'm on the fence about, but I'm not so sure I need to go there. but so much of the information is confidential. I'm still struggling to make sure that I don't. So why don't we do the cross and then just come to us at the end of the confidential cross and see if we have anything to add, like in the same session. I just wouldn't give us our own confidential session. I think it would be so limited, it wouldn't be worth the hassle.
Yeah, so let's I think we're just gonna have to feel our way through it. If that's all right, Mr. Larson. Commissioner Plant, do you have confidential questions?
I do not.
All right, so maybe at the end of the confidential session with the witnesses, Mr. Larson, if I have questions or Commissioner Gilman or questions arise for Commissioner Plant, we'll try and ask them then.
Thank you. And to the extent, just to be able to signal to Mr. Eiley, if one of our panelists has something to add to his answer, is it acceptable for them to use the hand raise function? I know that seems minor, but we're doing this for the first time.
Yeah, that would be our request, and I'll try and run the panel with the hand function and just taking cues from the witnesses.
Great, thank you. So when the time's appropriate, I'll introduce all of the witnesses simultaneously, and then we can move into the panel.
Ms. Keene.
Thank you. Following the company's lead, we also presented Mainspring's 2 witnesses as a panel, just for expediency. And so just want to confirm that the same processes for Fiesco would apply to Mainspring as well. They are also prepared to go individually if the commissioner.
I do not have confidential questions for Mainspring. Do you, Commissioner Gilman or Commissioner Plant? Commissioner Plant?
I do not.
Commissioner Gilman?
I don't think my questions for them are confidential.
And Mr. Kide, Mr. Dixon, do you have confidential questions for Mainspring?
Mr. Chairman, it's possible that we will. We don't know at this time.
All right.
I will add too that just to sort of help efficiency here, we don't know yet whether staff will have questions for Mainspring. We were just going to wait until after Ms. O'Neill finishes to make that decision at that time.
All right, so we'll just have to play it by ear, Ms. Keene, about how to orient to Mainspring. So maybe at the confidential session, we'll revisit this once we have the website cleared. Ms. Larry?
And sorry, just to remind that both the commissioners and the staff that are assisting, per your decision yesterday, we believe we have access to confidential information specific to Mainspring and bid 11, but we would not be participating in confidential information or sessions otherwise.
Fair enough. Ms. Larry?
Thank you. I just have a question about the process that you just decided with Mr. Larson. Is the plan to go through each party cross-examining the company with public questions and then go back through again with each party cross-examining the company with highly confidential questions?
Yes.
Okay, thank you.
Any other preliminary matters before we
Yes.
Mr. Kide?
Yes, I do. Thank you, Mr. Chairman. And I'm just obliged to say something here. So the staff supports the panel in this particular case, and we indicated that to the company ahead of time. And however, this proceeding reminds me of a Grateful Dead quote. What a long, strange trip it's been to get from the beginning to get to here. There's never been a proceeding like this, multiple hearings, complex questions, and now a panel of witnesses, only one of which has filed testimony in this proceeding in the past. So actually Ms. Jackson too, if you count Ms. Jackson. So my point is an unusual approach is warranted in an unusual hearing, but I was a little nervous when I heard how much you said you loved it and how much Mr. Larson likes it. I don't think staff would support this in other types of proceedings. It would be a case-by-case basis. So from staff's perspective, we do not want this to become a precedent. We'd like it decided on a case-by-case basis.
Fair enough. I can assure you an endorsement of this approach will not appear in our final order. So let's not litigate that now. And hopefully, if you're just adding your voice to Mr. Kynes, Mr. Fanyo, no need, but go ahead.
Okay.
Thank you, Your Honor. I have nothing from the Grateful Dead, but I do want to advise everyone that Climax will waive its cross of the public service panel. We had 30 minutes reserved.
Thank you, Mr. Fanyo.
Chair.
Ms. Laughlin.
If I may, just one request. So I'm looking in the documents that were just subject to admission, and I see some work papers from what staff just admitted that only have the Excel version. If you would so direct, consistent with your order, to get a PDF version and a public version, that at least a cover, that would greatly assist the record here by the end of the hearing. And I know, that might be today or possibly tomorrow. So if you could assist, I would recommend that direction to staff.
Mr. Kai and Mr. Larson, is that okay?
Well, the work paper, I'm told by the company, is entirely highly confidential. So
she's just asking for a cover sheet. So there's something there in the public record. It can just say the hearing exhibit number, and the entire thing is confidential, but it would help us. It would help the record to have a placeholder there. So that's
so the request is only to have a cover sheet for the highly confidential executables. That's public. That's the only thing we need to do.
Yeah. So the rest. So somebody looking at the public record knows what's going on.
Okay. I'm happy to do that. We'll get our paralegal going and we'll report back towards the end of the day. Thank you.
Thank you, Mr. Larson. Any other preliminary matters before we call your witnesses?
Nothing further from the company, Mr. Chair.
Would you like to call your panel?
Yeah, I've not called a panel before, so bear with me.
Yeah, well, wait till I swear them in. That'll be fun.
Yeah. So the company would call Mr. Jack Eiley, Mr. Justin Tomjanovic, Mr. John Bornhofen, Mr. John Landrum, and Miss Alice Jackson.
I guess, can you each raise your right hand and go one by one? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
I do.
Do. Seems like a wedding. Put your hand down. Is anybody with any of you or communicating with you in any way, including with each other? Mr. Tomjanovich?
No.
Mr. Landrum?
No.
Mr. Eiley?
No.
Mr. Bornhofen?
No.
Ms. Jackson?
No.
If that changes, will you let us know? And if you could go in the same order, that'd be great. Mr. Tomjanovich?
Yes, I will.
Mr. Landrum?
Yes, I will.
Mr. Eiley?
Yes, I will.
Mr. Bornhofen?
Yes, I will.
Ms. Jackson?
Yes, I will.
All right, back to you, Mr. Larson.
All right. Mr. Eiley, we're going to start with you. Can you please state and spell your name for the record?
Yes, my name is Jack Eiley, Jackihle.
And what is your role at the company?
I am Regional Vice President of Regulatory Policy for Xcel Energy Colorado.
And of the public service exhibits that were admitted via hearing exhibit 2904, were those prepared by you or under your direction?
Yes, they were.
Thank you. Mr. Tomjanovic, we will go to you next. Can you please state and spell your name for the record?
Justin Tomjanovic, JustinTomljanovic. And I'm Senior Vice President for Utility Finance and Corporate Development. And I'm okay if people say my last name incorrectly as long as the record reflects it correctly.
I believe I've already been saying it incorrectly. Thank you. Mr. Bornhofen, I will move to you next. Can you please state and spell your name for the record?
Yeah, my name is John Bornhofen, JOHN-BORNHOFEN. I'm the Director of Purchase Power for Xcel Energy.
Next, we'll go to Mr. Landrum. Mr. Landrum, can you please state and spell your name for the record?
I'm John Landrum. I'm the Director of Resource Planning for Xcel Energy Colorado, representing Public Service. My name is spelled JONLANDRUM.
Thank you. And Ms. Jackson, can you please state and spell your name for the record?
Good morning. My name is Alice Jackson, ALICE-JACKSON.
And what is your role at the company?
I am the Senior Vice President of Systems Strategy and Chief Planning Officer.
Thank you. With that, Mr. Chair, the panel is available for cross-examination.
Thank you, Mr. Larson. Mr. Kide, 45 minutes.
Thank you, Mr. Chairman and Commissioners. My name is Paul Kide. I'm a First Assistant Attorney General of the State of Colorado. I represent trial staff in this proceeding. And good morning to our 5 panelists. It's good to see you, especially Ms. Jackson. I haven't seen you in a long time. It's nice to see you again.
Likewise.
This morning, I want to have a short conversation with the panel in 4 areas. The first is I want to talk about the company's summer loads and resources table, and that'll be a public conversation. Then I want to talk about the company's renewable projects in component 1. That'll also be a public. And then when we get to the highly confidential session later, I'll have 2 categories. One is talk about the potential purchase of Plains End, and also talk a little bit about component 2 and CPCNs and how that might work, but that will come later. So I'd like to start out with the company's summer loads and resources table. And to do that, can we pull up on the screen from hearing exhibit 166, attachment JWI-19, the public version, and look on page 27. And when you get there, that's page 27. And if you can go to the table and just zoom in so all we can see is the table. Yep, table from, yep, there you go. Thank you. Okay, so because I understand from the testimony, Mr. Landrum prepared the table, so if it's okay, I'll just direct my questions to Mr. Landrum. Mr. Landrum, can you please give a high-level overview of this table?
Sure. This is John Landrum from Public Service. This is the most recent load and resources table that we filed in the Just Transition solicitation, the phase 1 in the middle of October. So this represents the company's most current and best information on what the resource position is in the near term.
And Mr. Landrum, during preliminary matters, I don't want to pull it up. The company stipulated to the work paper hearing exhibit 2710, that is the work paper associated with this table, correct?
That's correct.
Okay, so the commission has all the data that went into making these calculations now.
That's right.
Okay, Mr. Landrum, going back to table 1 on the screen there, I want to ask you 4 questions about the company's assumptions when making this table, and you already asked 1, so I have 2, 3 more. Mr. Landrum, is it true that there are 6 projects in the company's preferred portfolio that have adjusted their online project dates, and these adjustments are not reflected in table 1, the LNR table?
Sort of. We have several projects where the expected date of commercial operations, it has shifted from what the as bid was for a variety of factors. None of those projects are actively under construction, so there's lots of golf to be played, as they say, before we get to a point where we know for sure. But based on our current expectations, we have adjusted the in-service dates for the bids. We have not adjusted the in-service dates of the bids in this table. So we're sticking with the as-bid dates for the JTS LNR, which this is.
Next question is, A backup solar project, which was included in the calculations for this table, and that's bid number 151, has failed. And the reduction in capacity associated with that bid is also not reflected in table 1 on the screen.
That's correct. The bid is not reflected. The bid is included here. It has not been removed. That bid, currently negotiations are paused. The developer has indicated that they would not be able to move forward with the project even under the 6% component 1 relief. So we consider it essentially failed. Its exact status is subject to wording and debate.
And my next question is, are there any other changes like those, the assumptions underlying the table, that are not yet reflected in table 1 on the screen, which is also the table from Just Transition Solicitation?
Not that I'm aware of. The only thing that's really uncertain is the composition of row 21, the 2021 ERP CEP resources. That's based on the portfolio that we expect as of where we currently stand in this proceeding. Depending on how things work out moving forward, that line could certainly change if bids are changed.
Okay, now I want to focus on the last row in that table, and there's the numbers to the left. That would be row 33. And that row shows that the company's short on capacity from 2024 through 2031. In particular, let's look at the upcoming years. Now, based on the projects that were not in the portfolio, the failure of the solar project, is it correct to say that those shortfalls are going to be even larger if the table had reflected those changes?
That's correct.
And question for you, when I look at that row is, what is the company's plan to address the shortfall in row number 33, which is even larger than we thought when the table was created?
Point of clarification, you mean go year by year, or are you talking about specific years?
I would say go year by year.
Okay. For 2024, 2025, and 2026, it's very unlikely that new long-term resources could be acquired in that period. The options remaining to fill that gap are primarily shorter-term market purchases of capacity and/or energy. The company will actively seek to do that to the best of its ability. For 2027, 2028, there are some projects that are still in the backup bid pool that could be activated to close that gap. But that's really, in the company's position, the only viable new projects that probably would be supportive of the 2027 and 2028 position. For 2029, 2030, and 2031, those are the prime years that we look to fill through the phase 2 solicitation in this JTS.
Okay, thank you, Mr. Lander. Now I'd like to change to another subject. So let's go ahead and take the table down from the screen. And specifically, now I'd like to explore the different perspectives of trial staff and public service company pertaining to the stage 1 pricing methodology for power purchase agreements, or PPAs, and UOGs, utility-owned generation. Now, Mr. Eiley, I'm assuming I can ask you these questions.
Yes, Mr. Kide, you can. If I may, Mr. Chairman, I just wanted to offer just a quick point about this panel formation. This is new to all of us. I recognize that some of the witnesses here aren't as familiar maybe to some of the attorneys. And our thought was that if there's confusion, that could be a guide of sorts to which direction questions may go to. So I just wanted to offer that. But on this particular, back to Mr. Kayet's question, on this one, I'm probably the witness to take that. So if
thank you,
Mr. Chairman, our thought was that could be helpful as we maneuver across the panel.
Appreciate it. Back to you, Mr. Kide.
So to discuss this topic, I'd like to pull up hearing exhibit 2709, the public version. which is Staff Witness O'Neill's CEP delivery testimony. And specifically, I'd like to go to page 19, lines 1 through 12. Okay, just 1 through 12. Let's see. Yeah, thank you. Thank you. Okay. Mr. Alley, I'm going to read some of this, and then after I do it, I'm going to have some questions about it.
Great.
So Ms. O'Neill says, as proposed, the 6% figure represents different treatment for PPA projects compared to UOG projects. For PPA projects, the 6% applies to PPA price over the term of the contract. The 6% contract price increase is equivalent to 6% increase in the net present value, inclusive of all components, capital costs, PTCs, investment tax credits, O&M, capital additions, etc. Then she says, for UOG projects, however, the company proposes an allowed up to 6% increase solely on the project capital cost. This different treatment puts PPA and UOG projects on an unlevel playing field. So, Mr. Ali, did I read that correctly and characterize Ms. O'Neill's arguments correctly?
Yes, you did.
Okay, so basically what we're talking about, PPAs, 6% to the NPV, UOGs, the 6% is solely to the project capital cost. That's the dispute, and Ms. O'Neill wants there to be equity between the two. So we can take that down, that down. And the company disagrees with that, and in the reply comments on page 99, I'm saying you, I'm assuming you wrote it, staff's proposal is complex and less straightforward. You said that, right?
Yes.
You also said it's not an apples to apples comparison between the two methods. Okay.
Yes.
On page 10, yeah.
Sorry, I didn't realize that was a question. Yes.
Yeah, there's no simple conversion between the NPV approach and what we want to use for UOGs. There's no simple way to convert the PPA process to the UOG process, right?
Yes.
And the company's complaining that the independent auditor could struggle to complete its work if the commission adopts staff's approach here too. Is that correct?
It could be a tension in completing that work on an expedited basis, which we're seeking to achieve here due to the timing needs of this case and this portfolio.
Okay. And also on page 10, I think that and I'm just paraphrasing here, there was, the company said that they were working through the mechanics of staff's proposal, and the company was committed to discussing the methodology with staff, and that the company could provide a update on its conferral with staff during the hearing. So, can you do that? How did the conversation with staff go?
Well, yes, I can do that. It was a great congenial conversation as always. We did some work to assess this, and I guess at a high level, I would say, in many ways, we're always trying to figure out where the utility-owned versus IPP ownership models can be made equivalent or not. Sometimes I feel like we're trying to make cats into dogs and vice versa, as we struggle to do that. This is an area in which it's not easy to do that, is what we found in our analysis. Our initial proposal was an attempt to make things approximately equivalent, given that there are fundamental differences in these ownership models. And when we did the analysis, and Mr. Landrum did some preliminary analysis, we saw numbers. I mean, I think there's sort of a hypothesis. We could talk a lot about this, but I think there's kind of a hypothesis that the NPV number might result in a lower cost to construct number. We didn't find that to be universally true. And at a high level, it depends on the timing of when you're making expenditures. It depends on the tax credit structure that goes into that translation. It would really need to be done on a project by project basis. And so we found it difficult to sort of unilaterally agree with that as a fair and equal treatment for both IPP and UOG generation. And we shared that with staff, and we are where we are today. I would say that our position, and we tried to explain that in the reply comments, is that there's a potential for the IA to look at this NPV as one type of metric to look at in the evaluation of company projects under component one, stage one. That could increase complications, and based on our initial analysis, it could take extra time. We don't know exactly how that's going to turn out. So I guess where we sit on this, and this is what we shared, and this is that you could do that. You could also live with the approximate approach that we proposed in our direct case. And you could also move over to the utility-owned generation alternative portfolio PIM that we proposed. And that's really what we shared with staff, and that's our position as we sit here today.
And so just to summarize that this meeting took place, I think it was last week, and the parties do not agree, staff and the company do not agree on the proper methodology to use here today. Company did not adopt staff's approach. Staff did not say, hey, the company's approach is the way to go. Is that a fair assessment?
Yeah, I think it's less that we did not agree, is that well, I guess we did not agree. We didn't agree yet on a method to do this.
Okay. And so you said it earlier, but I just wanted to confirm. The company could do it the way Ms. Leo wants to, but it just prefers not to.
We could attempt to do that and push that through the IA process under the proposed component one. We don't know what the results look like for the project, so I don't know that we know that that's better or worse for the company or customers as we sit here right now. Is it technically possible? I'm sure there's a way to attempt this, yes.
Okay, let me just shift gears a little bit, same subject. So in this proceeding, staff requested and the company provided updated project revenue requirements for each company-owned thermal project, as well as each company-owned wind project. And that's CPUC 56.3 and 56.4. You're generally familiar with that, right?
Yes.
Okay. And so the revenue requirement models that the company provided to staff, those provide the net present value for each UOG project on a yearly basis, correct?
A net present value on a yearly basis? You lost me there. Usually a net present value is the summation when you discount back to a single start year.
And that's in the revenue requirement calculation, right? It's all in there.
You might need to put this in front of me, because when you said on a year-by-year basis, that I'm sorry, I may be.
Yeah, if I put it in front of you, we got to go to confidential session, and that gets a little strange.
Sorry.
Yeah.
I just, okay. There's an NPV expression. Yes.
That's in the revenue requirement model. Okay.
Yes.
Okay. And so, and isn't it also true that there's updated capital costs for each individual UOG in those same revenue requirement calculations?
I may want to kick this to Ms. Jackson. And to be clear to the commission and everyone here, really, Ms. Jackson's role here is to represent the company-owned project proposal. So she may be a little bit closer to that math. Since I'm kind of not able to see it, I'd maybe ask someone who's closer to the development of that response.
Mr. Kite, would you like me to jump in?
Absolutely. Thank you, Ms. Jackson. For sure.
Okay. Good morning. For the record, Alice Jackson with Public Service Company of Colorado. In regards to CPUC 56.3, the numbers that are utilized to calculate the revenue requirements, as well as the other subparts, reflect the updated capital costs associated with the utility-owned generation assets.
Okay, thank you. So, Ms. Jackson, the company possesses all the information it needs to treat UOGs the same as it does PPAs in the updated revenue requirement documents, doesn't it?
So Unfortunately, Mr. Kide, I am not as familiar with the staff's recommendation as Mr. Eiley is
Sure.
on the calculation of the comparison. This is one of the pieces of this panel that's going to be a joy today. And so I don't have that update. So I cannot say whether or not that particular revenue requirement has everything staff is looking for. But it does have the components to calculate a revenue requirement. It does have the components to calculate a net present value. And I don't know what else though Mrs. O'Neill was looking at in order to process the proposal she had put forward.
Thank you, Ms. Jackson. Okay, I'd like to turn to another related subject here, and we don't need to pull it up, but on page 11 of the response, the company talks about pathway 2 here. So basically what the company's saying is if we want to use Ms. O'Neill's approach, we kind of like to add this pathway 2. And part of that pathway 2 is that the company wants to use what's called a progressive method. And Mr. Eiley, did I frame that up correctly? I'm just looking for a yes or no answer here.
Yes.
Okay, so am I correct that the purpose of the progressive method is to give the company some risk relief?
It is in this circumstance in which costs of supplies, and therefore the prices of these projects is we've got upward pressure on both. And in the context of using, potentially using staff's proposal to translate these MPVs over to a cost to construct, which may result in a lower cost to construct or may not, we are seeking additional risk relief by way of the progressive method, as we describe it in the deadband in the PIM application.
This risk relief is not available to the PPAs, is it?
They don't have a PIM.
Okay. So your answer is yes?
That they don't have a PIM to seek relief from.
And so therefore they don't have the same risk relief that the company has if we use the progressive model.
No, I struggle with the premise of the question because they don't have that direct PIM applied to them. Therefore, I don't know if that relief question is totally relevant.
Okay, let me check my notes for a moment. Okay, thank you to our 5 panelists. And I have additional questions when we get to the highly confidential session. And for now, thank you, Mr. Chairman. Thank you, commissioners. And Mr. Chairman,
I have about 15-20 minutes left for you. So thanks.
Good. Thank you. I'll aim to come in under that.
CEC, 30 minutes.
Yes, thank you, Chairman Blank, and CEC is actually going to waive our time. So thank you.
Thank you. CEO, 20 minutes.
Good morning. Morning, panel. Nice to meet you all. I'm Jessica Lowry. I represent the Colorado Energy Office. I am going to look at my notes, so I can't look at you all. So any head nods, I won't notice, just to give you a heads up. Okay, I have some cross-exam for Mr. Landrum that may require highly confidential, but I think he also might be able to answer it without going into highly confidential session. Could I get started and see how far we go?
Yeah, please.
Okay, thank you. Could we bring up hearing exhibit, well, attachment JPD2 to hearing exhibit 1205. And that's an attachment to Ms. Durke's response testimony. Okay, thank you. Could we scroll down to the bottom, please? Thank you. Okay, Mr. Landrum, could you confirm that this discovery response is dated October 1st, 2024, and that you are the sponsor?
I confirm.
Okay, So first I would like to look at the response to, oh, sorry, I wanted to say this is Public Service Discovery Response to CEO 7-8. And I would first like to look at the response to 7-8A, which shows 2 tables. Here we go. Okay. The first table is from the 2024 annual report, which was filed on April 1st of 2024, right? Is that correct?
That's correct.
Okay. And the second table is from the testimony filed with the CEP delivery motion on September 6th. Is that correct?
That's correct.
Okay. And they both show the accredited capacity values of bids that were approved in this CEP ERP. Correct?
I believe that's correct.
Okay. And then this table is consistent with what would be included in a loads and resources table, right?
Yes.
Okay. And then could you confirm that when the capacity is listed in this table or in a loads and resources table, it means it's available for the entire summer of that year, beginning at least by June 1st?
That's correct. We're currently using a methodology where a resource needs to be available the entire summer period for it to be included as a capacity resource for that summer.
Great, thank you. So in other words, if a resource comes online in mid-July, say 2027, that resource wouldn't be added until 2028.
For purposes of this LNR spreadsheet, that is correct, just because you have to have a methodology to follow. Clearly, if a resource comes online midsummer, they'll provide some level of reliability benefit to the system in real life, which is a very different thing than the methodology by which this table is constructed.
Okay, thank you. And then could we look at the first table? And we're going to focus on bids 997 and 989. The first table shows that bids 997 and 989 will have 190 megawatts of capacity beginning in 2027, right?
That's correct.
Okay. And then if we scroll down to the second table and look at bids 989 and 997, the second table shows that 989 will have 190 megawatts of capacity beginning in 2027, right?
That's correct.
But now bid 997 doesn't have capacity until 2028, right?
Per the way this table is constructed and the methodology associated with it, that's correct.
Okay. Does the company still anticipate that bid 98989 will have capacity before June 1, 2027?
We certainly hope so. That project has not been constructed yet, or frankly, much progress on the physical construction done yet. So there's a lot that can be happened between now and then to mitigate that construction schedule. There are some challenges that we foresee with it being available by June 1st. But frankly, there is no definitive in-service date at this point. We're striving to do the best we can to manage that project, and we'll do so in the future.
So you said the company does not have an idea of an in-service date for 989 right now?
We do have a projected in-service date based on our best available information as of this time.
And what is that date?
I'm gonna have to defer to Ms. Jackson on this one, or look up in some reference material for the exact date.
Ms. Lowry, would you like me to jump in?
Yes, please. Thank you.
For the record, Alice Jackson with Public Service Company of Colorado. The anticipated in-service date that we are working towards for the bid number 989 is prior to summer, so before June 1 of 2027.
Okay. And 997, what's the expected in-service date?
For 997, the expected in-service date on that one is also prior to summer of 2028.
I'm sorry, I think for 989, you said 2027. Is that correct?
for 989, as indicated in this table, accredited capacity available for summer of 2027. So that would be prior to June 1 of 2027.
Okay. So your expected in-service dates for those two resources have not changed from this table?
That is correct.
Okay. And what about bid 1000?
Bid 1000 for those two, for the two assets that are included in there, we have on the first asset, which is commensurate with asset number in 997, same deadline. For the second asset that is included in that bid, it is at risk, I would say, of making a June 1 deadline. We are looking at more likely it's going to be a July deadline for that one.
For 2028.
Correct.
Okay. Okay, can I confirm with my team for a minute?
Yes.
Okay. Oh, I have to turn my microphone. Okay. Okay, thank you. I don't have any more questions on this topic, but I do have another topic to go through with I think, Mr. Eiley. Okay, let me get back to my notes. Okay. So for this set of questions, I wanted to ask about one of the three findings that Public Service is asking the commission to make. The commission chooses to wait until the follow-on CPCN proceedings to approve cost increases for utility-owned generation resources. And that would be part of component 2. So could we bring up Public Services CEP delivery plan reply comments, which is hearing exhibit 166, attachment JWI 19.
And this is the public version, just so you know.
Yes, that's fine. And then could we go to page 18? Scroll down, please. And I just wanted to confirm that the comments in this section, section B, titled Regulatory Relief for the Component 2 Preferred Option, is responding to CEOs and staff suggestions that any cost increases for utility-owned thermal units should be decided as part of follow-on CPCN proceedings. Is that correct?
Yes, it is.
Okay, thank you. And then could we scroll down? I don't have the exact page, but it's where it lists finding 1, finding 2, and finding 3. Okay. Okay, so I wanted to talk through finding 3. Finding 3 says, for purposes of any future CTC PIM calculation, the market dynamics described in the CEP delivery plan filing are, if established by the utility, to have cost impacts on the projects as delivered compared to the CTC baseline, extraordinary circumstances within the terms of the CTC PIM, subject to future adjudication by the commission following development of the project in question. Similarly, although potentially less applicable, the same would be true for the operational PIM. Did I read that correctly?
Yes.
Okay. Could you tell me in layperson terms what this means?
Yes, I can try. First of all, we do maintain our position that we have presented sufficient evidence, and this was back on page 18, that the price increases we're seeking on those units are approvable here. But we respect and understand the parties' viewpoints on this component 2 of our plan and appreciate the constructive input. And upon reflection, moving to your question, Ms. Lowry, on finding 3, really the notion is we would maintain the as-bid amounts that would be, in my view, still enjoying the rebuttable presumption of prudence. But with the additional amounts, we could have a presentation within the CPCN finding and the ability to argue for those additional amounts But what we're seeking here from the commission is a recognition that the market dynamics that we have provided fairly extensive record on in this case, in our view, are appropriate criteria to be considered as extraordinary circumstance within that CPCN process. So in essence, it allows us to argue from that standpoint that these factors we've discussed about, the geopolitical factors, the trade factors, the supply chains, all that, are factors that we can argue for as being deemed those applicable to those extraordinary circumstances within that CPCN proceeding.
Okay, thank you. So now I want to ask kind of about specific text in here. When it says, if established by the utility to have cost impacts, does that mean that the company alone gets to decide whether the market dynamics affected the CTC, or is that something that the commission would be deciding in the CPCN proceeding?
I mean, I think what this is representing, it's a great question, and it almost feels like a legal one in a way. I think what we're trying to represent here is that we would propose, CPCN filing, it's an application. So we would propose it, and if it were established by us, that those do have the cost impacts, those are basically approvable as additional costs through the extraordinary circumstances language.
Okay, thank you. That's helpful. And then when it says subject to future adjudication, does that mean adjudication in the CPCN proceeding or in a different proceeding?
I'm pausing to read it very carefully, if you don't mind. I think it's alluding to future adjudication because of the last few words of the sentence, which is following the development of the project. So the CPCN would precede the final online date of the project. This is allowing the commission essentially to review those costs that were put into the project after it's developed. But with this finding that we're seeking, that these are essentially, let's call it eligible extraordinary circumstances.
So could that finding change in future adjudications by the commission after the project was developed?
I don't think the finding that these are appropriate circumstances that we can legitimately claim through the extraordinary circumstances route changes. I don't think that changes. I think what could change is whether some expense fits that criteria.
So is it saying that in a future adjudication, the commission could change its decision about whether to allow the company to recover certain costs?
I think the commission could do that. But again, what we're seeking is to change the framing of extraordinary circumstances up front as it does so. So both within the CPCN and in this unnamed future adjudication, the commission would have these criteria, really these market dynamics we've discussed, as part of the rationale that the company can argue for. And if the commission deems in a future adjudication or in that CPCN that some cost increase is not due to these market dynamics in play in this case, I guess they can not approve those.
Mm-hmm. So is it correct, if I paraphrase, that what you're asking for here, the finding that you're asking for here is a determination that market dynamics that change the cost of a project could be considered extraordinary circumstances that could then lead to approval of additional cost recovery?
Yes.
Okay.
You may have said it better than I did, so thank you.
Thank you. Okay, I just have one more question, and that's about the last sentence about an operational PIM.
Yes.
How would changes to the cost to construct a resource affect the operational PIM or the operation of that resource?
I'm sorry, can you repeat the question? I just want to make sure I got that right.
Yep. So based on the last sentence that says similarly, although potentially less applicable, the same would be true for the operational PIM. My question is, how would the change in the cost to construct a resource affect the operational PIM or the operations of the resource?
It may not change the operational PIM. I think we've had some discussions about the equivalency of IPPs and utility-owned generation this morning. And in effect, and through Ms. O'Neill's testimony, the PPA increase allows IPPs essentially to account for some future O&M costs to run the project, like some price increases across that, which we didn't seek through the cost to construct the utility-owned project. We're saying here, in a similar vein to the discussion we just had about our ability to argue for increases based on these market dynamics, this might be true for O&M factors as well.
Okay, thank you. That's really helpful.
Yeah. Thank you.
If I could just confer with my team one more time. All right, we have no further questions and we don't need to go to highly confidential session. Thank you all very much.
That is some quick conferral, Ms. Lowry.
They're sitting right in front of me.
All right. CIEA 45 minutes, and just so you know, we'll probably take a break around 10:30, 10:35.
That works for me, Mr. Chair, and I have 3 topics, and so I would propose maybe I get through the first topic and I'll let you know, and then we can break at that point.
Yep, and Mr. Dutsky, do you have confidential questions or not?
I am hoping that I do not have any confidential questions.
All right, fire away.
Thank you. Good morning, esteemed members of the panel, and Ms. Jackson too. Welcome back to the show.
Are you suggesting Miss Jackson is not esteemed?
No, that was not
That is not been my experience.
Her esteemedness is well known. I had 3 topics for the panel today, and I think a lot of my questions were intended for Mr. Eiley. And so I guess Mr. Eiley will be my default, but anyone else can please weigh in. And the 3 topics that I'm going to discuss are: first, power purchase agreement terms presented in public services reply at a high level. Second is the component 1, stage 1, competing proposals of the company and CIEA. And third is a discussion about project risk as it relates to the current state of PPA negotiations. I want to start, Ms. Frederico, with hearing exhibit 2204, which is the COSA SIA set 4, and I'm looking at page 3, which is COSA SIA 12.1. Thank you. First, Mr. Eiley, to be clear for the record, that with its JWI-21HC, the PPA term exhibit, the company makes no request of the commission to act on any of the PPA terms that the company presented in that exhibit. Is that correct?
That's correct. We were being responsive to a request from the commission.
Okay. Ms. Frederico, can you scroll down to capture this response? Thank you. Starting with the last sentence here, the company doesn't accuse the 3 project developers behind these particular paragraphs of bad faith or unreasonable negotiating tactics. Is that correct?
That's correct.
Okay. So in this attachment, you also state that the 4 examples the company provided are from 3 separate PPAs. Is that correct?
That's what's stated here.
So is that correct?
You know, the sponsor of this is Mr. Bornhofen, who is right here on our panel. So I may have higher confidence in his assertion about that.
I can answer that question. This is John Bornhoffen, Public Service Company. The answer is yes. Three different developers.
Thank you. So that means that there are 8 PPAs that are currently being negotiated from the CEP that are not referenced at all in this exhibit. Is that correct?
Not necessarily. There may be a developer or a bidder that has multiple projects where these same requests were made across multiple projects.
Okay.
But generally speaking, there are other projects where these requests were not made. You're correct.
Okay, thank you. So in the company's reply, and we don't have to turn to it just yet, but unless you want to, but the company stated, quote, "We recognize that there were always 2 points of view in PPA negotiations." Do you recall that statement?
I do.
Okay. And I agree with that statement, but to be clear, we don't have this second point of view in the record or any of these PPAs represented in full. Is that correct?
Mr. Deska, my audio is a little muted and I literally didn't hear the last couple words before you said, "Is that correct?" I'm sorry.
I think I said we don't have the full PPAs in the record.
I don't believe we do. I don't believe our statement represented specific PPAs. It was a very general statement that we were respectfully noting that there are differing views on the approach to the contract negotiations.
Right. And the company also admits that the company itself has made certain changes to the PPAs during the course of the negotiations. Isn't that correct?
Can you point me to that?
Yes. We can go down to this same hearing exhibit that we're on, and we could scroll down, Ms. Federico, to page 7 or 6 and 7, which is COSA 12-4, where, I'm sorry, can we stop at the question so Mr. Riley can see the question? Where you were asked if there had been any changes, and then if you go down to the response, Ms. Federico, the next page. Thank you. Does that refresh your recollection, Mr. Riley?
A bit. Is Mr. Bornhoffen the sponsor of this discovery request?
Yes, he is. Mr. Bornhoffen, same question.
Yeah, would you mind repeating the question, Mr. Detsky?
Yes, the company admits that the company has requested certain changes to the PPAs through the course of negotiations with IPPs. Isn't that correct?
That's correct.
Okay. And it's correct, Mr. Eiley, that none of the counterparties to the company in these PPAs are parties to this ERP proceeding. Isn't that correct?
I believe that is correct. We had an intervener join the case, but I believe they're not a counterparty to a PPA. Rather,
thank you. Sorry to interrupt.
I believe that's correct.
If these counterparties to the PPAs are not parties to the ERP proceeding, that means that they don't have access to this highly confidential exhibit on PPA terms. Isn't that correct?
They should not.
So, if that's the case as well, then these counterparties could not so much as even review what the company presented in this highly confidential exhibit, correct?
That's correct. They're not parties. They've not signed NDAs to the highly confidential terms. So yes, I agree.
So just to wrap this up, of the two sides with potential viewpoints, as we noted you discussed, the commission only has one side in the record. Isn't that correct?
Mr. Deskey, I believe you represent independent power developers. So I believe that you represent the other side of the perspective, as well as the other two IPP trade groups that are parties to this case, those being COSA and Interwest.
But I represent a CIA and IPP trade association, not the counterparties to the PPAs, correct?
I don't know which counterparties may be your members or COSAs or Interwests.
Correct. Mr. Chairman, that's the first part of my cross, so this is a good breaking point for me if it is for you.
How long is your second part?
It's longer. It's the longest part.
Yeah, why don't we take a 10-minute break and come back at 10:35. 10:35. Thanks. Mr. Detsky.
Thank you. The panel all back. I see Mr. Riley. It's good enough. Start?
Yeah, I think we can go ahead.
Okay. The next topic I'd like to turn to is the stage one, component one of the CEP delivery proposal. My first question to set the stage, Mr. Riley, is right now, delay is the enemy of success of the CEP delivery. Is that correct?
I agree with you.
And would you agree with Mr. Eiley or other members of the panel that right now for projects that have been approved in the CEP, costs continue to increase on a month-over-month basis?
Generally, I mean, as developers, including the company, are seeking to develop things, we have to order equipment, we have to reserve contracts. Those usually have costs, and as time goes on, those costs can add to the cost of the project before the revenues start to accrue on generation.
So can we say that delay is functionally equivalent to cost increases right now?
I think that's a pretty good statement.
And each additional month of delay also puts pressure on the company and IPPs to meet their as-bid commercial operation dates. Isn't that correct?
It is.
So one last question just to set the stage. CIA's contention for this stage one, component one, is that the IA, the use of an IA is somewhat futile and problematic from a timing perspective, and the company has concerns with CIA's approach and its reply. Is that fair?
It's fair. You know, we propose the IA as a means to credibly provide the commission with information that they could feel comfortable with in granting these price increases under our proposal.
And we're going to get there.
Okay.
What I'd like to do is start off talking about the process and schedule you've proposed. So, Ms. Frederico, can we turn to Mr. Eiley's testimony, hearing exhibit 166, Rev 1 at page 40? And I'm looking at lines 6 and 7. Mr. Eiley, has the IA been retained as of October 15th, 2024?
Mr. Landrum has been leading the sort of project to go select an IA, so I may kick some of these processes to acquire one to Mr. Landrum. Sorry, Mr. Detsky, for the inconvenience.
No problem.
Yeah, Mr. Detsky, can you repeat that question, please?
Has the IA been retained as of October 15th?
It has not. We are in discussions with a potential candidate, but there's not been any contracts executed.
And the company won't execute contracts until it receives commission approval. Is that correct?
That's correct.
So we heard this morning statements of position just before the holiday. So we can hope for a commission decision sometime around middle of December. Is that correct?
That's my understanding of the current proposed schedule. That's correct.
And once the IA has been retained, the company proposes to then work with the IA to establish scope and budget estimates and then file a motion with the commission. Is that correct?
I'm not really the witness to talk about the regulatory procedural schedule.
Yeah, sorry, Mr. Detsky, I believe that is correct.
Okay. Do you anticipate that the motion would propose a standard of review for the IA?
You know, I believe our intent is to collaborate with staff and develop the parameters under which the IA would operate.
Okay. And it's not until we have that collaboration and that motion and approval of that motion that IPPs or the company would know what the scope of the IA's review is going to be. Isn't that correct?
I don't know if I fully agree with that. We've suggested some of the scope of review within our testimony, within our direct proposal here, and that was actually done with input from IPP developers with approved projects in this portfolio.
Okay, and we'll get to that in just a second. I just want to note that you had originally proposed here that company and IPPs would submit their revised pricing on New Year's Eve, December 31st. Do you recall that?
Yes.
That's no longer going to be the case, right?
I'm not sure that that's foreclosed yet.
Okay. You also proposed that the IA's review would be done by January 30th. Is that still on the table as well?
It's true that we envisioned a 30-day IA review cycle. And so
Okay.
if 12/31/24 holds for the submission to the IA, then 1/30/25 still holds for the IA's judgment, if you will, or a recommendation to the commission. And I believe that's what Mr. Landry has been discussing with the potential IA candidate.
And you refer to the IA's, let's turn to page 43, Ms. Federico, on line 3, please. Okay. And you propose here that what the IA would be doing is a verification. Is that correct?
Yes.
And the repricing verification would be followed by the IA filing a report with the commission. Is that correct?
Yes. So the thought is that the developers, including the company, would have this information first, and then there'd be follow-up, time to develop the actual filing to the commission after that.
And then you go on to propose a process of comments and adjudication by the commission, taking us through roughly the end of April 2025. Does that sound right?
Yeah, it does. When I've added these dates up myself, that I believe that's where I got to as well.
Okay. And scrolling back up here to page 41 on line 9, you say the IA would have the authority to verify and concur with a price increase. Do you see that?
Yes.
Is concurring anything different than verifying?
I don't know that it is.
Okay. So you also propose in your testimony that the IPPs and the company would have a broad discretion in what they provide the IA, and then the IA would have the discretion to either rule on that or to ask for further documentation. Does that sound correct?
Yes.
In your one of the concerns that you had talked, I'm done with this exhibit, Ms. Federico, thank you. One of the concerns that you had raised, and we can turn to CIA's comments if necessary, was that CIA's proposal to not have the IA in stage 1 would not provide sufficient assurance to the commission about the price increases being appropriate. Do you recall that concern?
Yes.
Okay. So would you say that this somewhere in here between sufficient assurance, verification, concurrence is sort of what we're looking at as a standard of review for the IA?
Yes.
So do you anticipate that the verification by the IA and the concurrence in this 30-day period for 20 projects would involve a verification of the amount of the increase? And let me explain one more thing before you answer that. What I mean is the percentage amount. If an IA or the company, if an IPP or the company says, here's our documentation for a 6% increase, do you expect the IA to concur and say, no, we concur, but your increase is 5%? Or do you expect the IA to say, we concur that this increase is appropriate?
Are you asking if they have the ability to concur with something less than the full request?
Yes, could the IA review and say, well, I've looked at your documents and you asked for 6%, but you're going to get 5%?
I think in essence they could. I think that the way that we phrased it was that they could agree with parts of the request. They have that ability to do that. So that likely means that they could be approving or concurring with something less than the full request.
And in order to make that kind of determination, don't you think that an IA might need to do a deep dive into the costs of each project as they were bid versus what they are now?
I mean, our thought is that project developers, including the company, can provide enough substantive information so that an IA can put its verification with confidence, with its brand behind it, in front of the Colorado Public Utilities Commission.
And do you think that an IA can make this with confidence, as you say, determination for 20 projects plus a report in 30 days?
My understanding is from some of the discussions that there are sufficiently resourced firms out there that can do this. It's not free. And I would point out, it's not a question you asked me, but the alternative portfolio PIM is one way to reduce that load on an IA and also reduce the load on the commission to approve the IA's verification process. It's one way to reduce that piece. And I don't necessarily disagree with you that this workload and this timing balance is a balance, Mr. Detsky. And it's another example of that we struck this point with this recommendation on balancing the need for good information with timing. We didn't give them a ton of time, but yeah, there's room for more than one view here as well.
What about the backup bids? Would they also submit their repricing requests at the same time?
Yes.
So we're looking at more than 20 projects potentially. And what about instead? Would the company expect that the IA might do a higher level check? And the verification would be more of, is this documentation commercially reasonable without sort of digging under the hood on everybody's proposal?
You know, I really think that's a question a little bit more for the commission.
Well, I definitely agree with you.
As a developer or project developer or owner here, could we accept a less less burdensome process? Yeah, certainly. We thought we advanced this concept to with the public interest in mind and ensuring that these cost increases were sufficiently demonstrated for the confidence of the commission.
And further to that confidence point, what if the IA's review was, in terms of commercial reasonableness, was sort of like sussing out fraud from, as I say, a commercially reasonable attempt to document the price increase?
What's the specific question? Sorry.
I'm asking about the sufficient assurance being more of a screening, checking for fraud versus parsing 5%, 4%, 6% increase.
I see. Are you asking if we could accept that?
Yes.
I mean, on behalf of the company's development activities and ownership plans, I think that's fine with us.
That would potentially greatly expedite the IA's ability to review all these projects, correct?
I think it could reduce their workload. I don't know if it gets these things done faster or not. I don't know if I know that.
Now, are you aware that the commission just yesterday entertained a proposal from Black Hills utility about price increases of up to 5% for projects in its CEP?
I heard a little bit about it. I'm not intimately familiar with it.
If the commission were to approve a price flexibility, in this case, 6%, that did not require IA of approval in stage 1, would the company be willing to accept that process subject to a finding, as you put in your comments, that such actions would be establish a prudent actions on behalf of the company?
Can you run that by me one more time?
Yes. Would the company be okay, subject to a assurance of prudency, that without an IA, there could be price flexibility up to 6% for CEP projects?
Yes.
Now, just to be clear, CIA's proposal is still that the IA would be required in stage 2. Does that sound correct to you? As you understand it?
I'll take your word for that. I can't quite remember that detail. Apologies for that.
And right now, unfortunately, it's looking like stage 2 is more likely than it was before. Would you agree with that?
I would agree that I am glad we put a stage 2 in.
Fair enough. Let's talk about if a project is denied a cost increase by the IA. What would happen in that case?
I mean, process-wise, it's basically a recommendation to the commission. I don't think the IA unilaterally determines that. I don't know if we envision this specific scenario, but I think in concept, the IA could say we don't verify that, and the commission could grant it. I probably think that's less likely.
If public service were to be denied a requested price increase, would it move forward with that project that was so denied?
I don't think I can answer that today, Mr. Detsky. These projects are all really important for resource adequacy. That gets into a really tricky question for us to answer. And that's frankly, that's tricky for us to answer as the party responsible for reliability for the economy of half of Colorado, than for a developer that chooses to leave the project.
So it's too early, as we sit here today, for the company to commit to move forward with each utility-owned project, regardless of what the IA decides, correct?
Objection, speculation, asked and answered.
If you want to rephrase, Mr. Detsky.
Would the company commit right now to move forward with all the UOG projects, regardless of what the IA decides?
We're committed to our proposal to use an IA process to evaluate these price increases. We think we can make a good case to the IA for these price increases and subsequently to the commission for these price increases.
So does the company envision the commission as sort of a potential appeal of what the IA decides? In other words, the commission would review what the IA does and the company could question the IA's decisions to the commission?
I mean, it goes from the IA to the commission in the decision process. I don't know if I've really thought through sort of what an appeal process looks like at the commission.
But if the company were to have an adverse decision from the IA, would the company expect the ability to address that and ask for relief despite what the IA found?
I honestly don't know. We might have to brief that issue. Don't know. This is all very new ground, right? So I don't know on the back end of the process what sort of appeal rights we want to maintain right now.
Okay. Would you agree that an IPP should have whatever appeal rights the company has for its price increase requests?
That's an interesting one too, because they're not in the case, or they're not in this proceeding.
Correct.
I don't know that I conceptually disagree. I guess I don't know procedurally exactly how that would be done.
So let's talk about this last part of this section, the CIA's proposal on competitive tension by incentivizing companies to request a lower percentage price increase. The company responded to this proposal in reply comments, correct?
Yes.
And do you agree that it's quite likely that many of the projects will need the full 6% proposed by the company?
I think there's a good chance many of them would request that and probably need it.
Okay. And do you agree that for an IPP, they might find some risk in the process that we just went through, meaning what the IA will review, what the scope of that review is, what the decision might be, the appeal rights, etc. Do you agree that might present some risk to IPPs?
Yes, and to the company.
So if a project could skip essentially the IA review and go straight to contracting at some lower level increase, whether that's 1 or 2%, do you think an IPP or the company might find that attractive in some cases?
In theory, yeah, I think you're saying they get a certain 2%, or they can go argue for 6% through this process that has two decisions really. It might be appealing.
And
I don't know if I can answer. I mean, they're your clients. I don't know if I can answer for the IPPs, but in concept, I could see that being attractive.
But again, for clarification, my client is the trade association, in this case, it's not the companies you're talking about.
Well, that's an interesting distinction, but okay.
So if there was an expedited process, that might also allow projects to move to construction and financing quicker than if they have to go through the entire process we just discussed, correct?
If there was a shorter timeline process, yes. Yes.
And that would help them meet their as-bid commercial operation date, correct?
It would help us too, and I agree with you.
Now, if on this hypothetical, if an IPP or the company chose to go this route of an expedited process, that would represent a reduction in the cost of the CEP delivery motion as compared to the company's estimates that it presented originally in September. Is that correct?
If the commission adopted this recommendation and a certain fraction of those projects went with the lower increase, faster, more certain route, it could be a cost savings. Yes.
Okay. The last subject I want to talk about with you today is the subject of project risk and PPA negotiations. Earlier today, we started off our discussion with agreement that delay is a top driver of the need for commission action here. Do you recall that discussion?
Delay and price relief.
Yes.
Yes.
And we discussed how each additional month of delay, whether that's the process we discussed with the IA or just executing a PPA, more than likely increases project costs. Do you recall that discussion?
Yes.
And each additional month also risks on-time delivery of these projects versus their bid COD, correct?
All else equal, correct.
Okay. And what we've just walked through with the filing that was made in September, with no essentially pausing all projects, correct?
I don't know that I'd argue it's pausing them. I think the decisions in this proceeding could allow projects to proceed with some of their activities. And that's what we're trying to do as project. Get enough certainty out of this process so that we can take steps forward.
Well, let's say there were 11 PPAs that were not signed as of the the filing of the CEP motion, correct?
I believe so.
And there have been no PPA signatures since the filing, correct?
I believe that's also true. That's a better question for Mr. Bornhofen, but I believe that's likely true.
And your process, as the company's proposed it, takes us into May of next year, correct?
We agreed on April earlier.
Sorry, April, I forget. If a CEP project is withdrawn, that's a big risk to ratepayers. Would you agree?
It could be, yes.
Because the ratepayer risk with the CEP projects is resource adequacy and reliability, correct?
That's one risk, and then if we have to resort to a backup bid, which we likely would, there's also a risk of a price increase.
And even Mr. Landrum earlier this morning talked about the need to having to potentially go to the market to just buy energy capacity on a short-term basis if there are not enough projects in the portfolio, correct?
That's one of the options we use to fill in resource adequacy shortages, yes.
So given this discussion we've had, isn't it true that the commission here has some degree of control over CEP project delay? Do you agree with that?
I do, based on the process they approve here. I do agree.
And sorry to interrupt. And that's in comparison to things like tariffs, for which the commission has no control, correct?
Correct.
And the commission has no control over things like inflation, supply chain risk, correct?
Last time I checked, they do not have control over inflation.
So if we're agreeing that delay is the top driver, that delay is what's driving, one of the factors driving month-over-month cost increases, and delay is a lever that the commission has some control over in terms of risk mitigation, should the commission consider steps that might involve quicker action on the CEP delivery motion than the company suggested in its filing as a viable way to mitigate ratepayer risk?
I think I can agree with you. I think the commission will need to consider that timing versus certainty of needing the price increase in its evaluation.
So I want to just contrast this discussion we just had about delay risk and the IA process with the PPA risk. So the company describes IPPs in PPA negotiations that the company is essentially negotiating on behalf of its ratepayers with these IPPs. And I'll try not to delve into any highly confidential information, but at a high level, do you recall making those kinds of statements that the company is essentially acting on behalf of its ratepayers to mitigate risk to them?
Yes.
If we could pull up the company's reply, which is attachment 19, I believe, to JWI 19, hearing exhibit 166, page 29, please. Thank you, Ms. Federico. Could you scroll down a bit? Okay. Oh, perfect. Thank you. Right here next to that footnote 63 in the top part of this, it says, having rigorous terms upfront creates incentives for a developer to keep the project and not abandon it at little additive cost. You see that?
I do.
And when you say little additive cost, what you're referring to there are financial penalties that an IPP would have to pay if they withdrew their project. Is that correct?
Just reading briefly for context. I agree with you.
Okay. And at a high level, when an IPP is requesting language about outs if you will, from a contract. Generally speaking, are we not talking about the same subject of financial penalties the IPP would face for withdrawing its project?
At a high level, yes.
Okay, because an PPA they can withdraw their project at any time. The question is, what's their penalty for doing that, correct?
Yes, and our view is the penalty is what's written into that contract, as that contract has been negotiated through phase 1 of the ERP process. We believe that's what they should be held to.
Okay, and we'll discuss that another time. For now, when that happens, your testimony here, or the reply comments go through that what the company does is it will collect those penalties and then it will return those funds to ratepayers. Is that correct?
Yes.
Okay. And so when that happens, the ratepayer risk is not in those penalties, right? Because they get paid. The ratepayer risk is whatever energy or capacity the company then has to go find to replace that PPA, correct?
Yeah, that's correct. Or potentially the reduction in resource adequacy.
And so that's why you say here down the bottom that the company feels strongly that conceding to PPA terms that permit project failures with little or no protection for our customers will ultimately cost our customers. Do you see that?
Yes.
So again, to clarify here, the protection for the customers is the financial penalties an IPP would pay, but the cost to the customers is what the company has to go and procure in the absence of that PPA, correct?
Yes.
Okay, so if that's the case, when the IPPs are pushing back on these outs as you describe, and that back and forth causes delays in the execution of a PPA, isn't the company essentially trading one type of risk for another?
I don't know if I can agree with that.
So you don't think that let me back up a step. Each back and forth turn of a PPA, if you will, to use the parlance, represents a delay to that project, correct?
No, I don't necessarily agree with that. I think there's an expected period of negotiation, and I don't know that I believe that should be built into project bids and an estimated online date. So I don't necessarily agree that I think what you're saying is like any step in a negotiation creates a delay. I don't know if delay is a good framing of that. I think that should be sort of a foreseeable period of negotiation built into the project timing.
And what's the length of that foreseeable negotiation?
I believe there's a number in the rules, and it might be 120 days.
Okay. So let's say we're going beyond the rules, 120 days, and the company's negotiating hard on behalf of its ratepayers. But that's causing project delay. And you don't think that there's a trade-off there between project delay and negotiating about what happens if a project withdraws?
The company is negotiating to ensure that the project has a high certainty of being delivered.
And don't you think that certainty is increased by execution of a PPA?
Yes.
And if a company does not execute a PPA because of these objections to the language on outs or withdrawals, the company could essentially win the battle but lose the war, correct?
The company, in your construct here, or your example, the company could be at risk of executing a very risky PPA, and that's the balance.
Agreed.
You have to sign a PPA that can be delivered.
Agreed. And in this process of the CEP delivery, the company is not proposing that IPPs in their PPAs get commercial operation date extensions that are equivalent to the 6 months that this CEP motion process is going to take, correct?
I don't believe that we've advanced that here.
I think in fact, Mr. Barnhofen can weigh in here, and I could show you the attachment, but Mr. Borhoffen said no on that, correct?
Subject to check, yes.
Okay. We can check right here because we have the panel. So based on this discussion, if the company were to execute PPAs sooner rather than later, that execution in and of itself increases the likelihood that projects will get developed. Is that correct?
No, I don't agree with that, because if we executed contracts that don't have adequate protection in them, then I don't know that it will increase the likelihood of the development of that project or the timing of it.
Okay.
It may provide a good platform for a developer to continue working on it, but I don't know if it's going to help us necessarily.
Well, in fact, a developer will not be able to do things like finance or construct without an executed PPA. Isn't that correct?
I don't know that for sure.
Okay. Thank you.
It
That's
depends
all.
on their particular business model and financing arrangements.
Okay. Thank you. No further questions, Your Honor.
And Mr. Detsky, again, you don't have any confidential questions, is that correct?
I do not. I think I successfully avoided it.
Thank you, sir. Ms. Keene, do you have a question before we turn to WRA? No. Yes.
Sorry, I forgot about WRA. I wanted to raise something prior to going into confidential session.
WRA has, I have 20 minutes across for you, 30 minutes across for UCA, and then I think we'll break for lunch a little before noon. So Mr. Barrasso, you're up.
Thank you, Mr. Chair. Maybe sooner than noon, WRA is going to be waving its cross at the panel.
All right. Thank you, sir. UCA.
Yes, Mr. Chairman, UCA also waves cross.
Oh, wow. Commission Counsel, I don't think you had any questions.
Correct, no questions.
Commissioner Plant, you are up somewhat quicker than anyone expected, at least me.
Yeah, buzzing right along. Thank you very much. And I just had a couple of questions, some that are directly to the testimony and some that are just more general, my understanding of how the company's thinking about some things to help me put within context. But to start off, I think you discussed, and I'll just go to Mr. Eiley and you can either take them or pass them to somebody else. In the testimony, you talked about the ISOC program, and there were proposed changes to the ISOC program in order to increase participation based on a belief that a change that happened a while ago has decreased participation. You'd like to go back to the other. Is that correct?
Yes.
And I'm wondering, in the load and resource table, in line 22, you've got your DR line there, and I don't know if we want to pull that up. It's hearing exhibit 166, attachment JWI 19. I think I have the highly confidential version here, but I think we would want to bring up the non-highly confidential version. Yeah, page 27, I believe. Yeah, there we go. Yeah, and if you could look at line 22, that's the demand response line there. Can you tell me, do the numbers in here reflect a presumption of increased participation in the ISOC program based on changing that compensation that's being proposed in the ISOC?
I don't know. I would say that our estimated number was about 10 megawatts of increase, but I may kick this to Mr. Landrum as his team assembles the L&R table. So, Mr. Landrum.
Thanks, Commissioner Plant. This is John Landrum for public service. It does not. That is just the base assumption for the JTS and does not include any incremental potential gains from reinstating the previous ISOC rate.
Okay, so according to Mr. Eiley, that if that were to go into place, your estimate would be that there would be an increase there of about 10 megawatts. Is that?
That's our best estimate as of this time.
And of this 283, 352, 335, 372, et cetera, how much of that is the ISOC program?
I would need to check that, Commissioner Plant. I'm not sure what the breakdown is. A good percentage of it is, I just don't have the exact numbers at my fingertips.
Okay, and along those same lines, you've got in other proceedings, you've got the development of a VPP program and more dynamic demand management that you're working on and developing that I believe should be in place by certainly within the period of this projection. And I'm wondering if that is reflected in this line 22.
It is. It's our best assumptions as of the efficacy, if you will, of our future efforts in the DR as of this point in time.
And so I mean, I don't think it's projected to be in place in 25, 27.
Sorry, Commissioner Plant, I'm not really prepared with the exact details of which year the different DR programs came in. We can certainly get information back to you if we need to.
I'm just trying to get an idea of the sort of the size of that program that you're anticipating contributing to line 22. It seems like, if we take 2025 as a baseline, for example, 352, if we go all the way out to 2029, that increases by about 35 megawatts.
Yeah.
Are you not anticipating any more than that you'll be able to derive from a VPP program?
Yeah, I think this is a good time, Commissioner Plant, to point out a difference here. This is the new JTS table. So what you're seeing here is the accredited capacity of the DR programs, not the nameplate value of the program. So there is larger growth in the nameplate size, but it's a smaller amount when you adjust it for the ELCC of the program. So again, I can over the lunch break, I can get some more information on the components of that individual line if we'd like to come back to it. But I apologize, I just don't have the numbers memorized for that.
Yeah, that would be very helpful. Thank you very much. Appreciate that. So you could take down the table. Just some general questions just to help me understand how the company is thinking about some of these resources. As I know you've heard me express some concern around utility-owned gas, particularly as it relates to the state's objectives around getting to zero carbon emissions and the sort of concerns that have been raised around what stranded assets might be falling on consumers for any period of time where we wouldn't be using those resources to contribute to the grid. But certainly that time frame also includes a transition within our system to include potentially a regional market. And I'm wondering how the company is thinking about the role of those fossil resources within a regional market.
I can maybe start on that, and Ms. Jackson may have some things to add as well. If we entered an RTO, a regional market, and we already are in a form of a regional market, but if we entered an RTO, one of the requirements is that we bring sufficient resources to that entry. Each individual entity is required to have sufficient resources. So at a high level, it doesn't necessarily change our assessment of the required resources, if that's what you're asking. And I don't know, Ms. Jackson, if you'd like to add anything more to that.
Yeah, so for the record, Alice Jackson with Public Service Company of Colorado. Howdy, Commissioner Plant. On this particular topic, there's many layers, as you know. When we think about the regional market opportunities, one of the major barriers or attributes of a regional market is the ability to transfer energy between the various participants in that market. I think you are familiar with the market here in Colorado and the fact that we have limited transfer capability between us and different regions in the West, also across the DC ties that would go to the East. So with that limited capability there, when we think about the regional market participation, it helps us from a cost standpoint to optimize inside of a day. But Mr. Eiley was correct. When it comes to the capacity accreditation and what you have to bring to that market, every hour of every day, we are required to bring to the market enough capacity to serve our customers. And so therefore, when we look at building out resource adequacy, doing our electric resource planning processes here, we still have to supply sufficient resources to that market to cover the needs of our customer base. So when you think about the gas assets here, they have a key attribute that they are playing in our market and for our customers from a resource adequacy perspective. They fill in the gaps when we don't have the zero carbon resources that are available on the system. Look outside today, for example, correct? We have limited solar availability on days like today, and we have multiple days in a row of that. So battery storage, while it could sufficiently cover a number of hours or potentially up to a day, multiple days in a row put our systems at risk. These types of resources, such as our gas thermal assets, provide the insurance for our customers at the end of the day to make sure that we have the adequacy to serve them around the clock. We also are strong proponents of getting to a zero carbon system. As the first utility in the nation to make the announcement that that's our objective, that is what we are ardently working towards. Unfortunately, the technologies that we need to be able to close the gap in this shorter time frame are just simply not available to avoid having the gas assets on our system in the near term. Thus, that is why we continue to be proponents of them in this ERP and the one that was just most recently filed.
Yeah, no, I understand the company's perspective on the role of the gas within our system and the resource adequacy. My understanding is that the projections are that these would be used about maybe 5% of the time, maybe a little less, which leaves the 95% that they wouldn't be used. And what I'm trying to understand is within a regional market, number one, do we see those resources during those other 95% of the time being utilized within that regional market? And number two, is there some sort of cost relief to Excel customers that could be presumed because those resources are not serving the customers, but they're serving a larger market?
Understood. So absolutely. So there's a couple of layers to this again. First off, in our examination of a regional market, one of the factors that doesn't exist in the current ones that we participate in as Xcel Energy, they do not have a climate component, meaning they don't look at carbon dispatch as part of the base. That is something that we are including in the conversations that we are having about the regional markets in the West, because we feel it is important to recognize the goals that the state has, the laws that are in place, and respect those in our territory as well as in others. So the layer of the dispatch, so how would these assets potentially be used in those regional markets, is twofold. First off, we would anticipate making them available to the regional market pursuant to their ramp rates, availability, et cetera. So they could be called on by said regional market to provide energy for other customers in that market, provided they are cost effective and deliverable. The other component of that, though, is what I was mentioning in regards to the carbon content. To the extent that the regional market develops with the carbon content, call them constraints, rules, requirements included in it, that would be another layer of its availability to be dispatched. Because for it to be dispatched for somebody else, they should assume that carbon that is then generated by operating that unit on their behalf. So there's the multiple layers. At the end of the day, your question is could they be used for others? And could that provide cost savings for our customers? Yes, they can be used for others. They would only be dispatched if it was cost effective for our customers, and those revenues would be returned to customers. pursuant to our rules of operation.
Thanks. And are there processes within the regional market that would allow, for example, if just to throw out an example, if in, say we join a market in 2030, and say we were to refinance our fossil resources to align their the customer obligation to pay for those resources with whatever our zero carbon date is at that point. And then any additional costs that might not be covered within that, could that be then attributed to a regional market? So for example, you would, basically set up, two books. One would be to pay off the component of that resource that would be serving a market. Another would be to pay off the component that we're serving the Excel customers here in Colorado. Is that a structure that exists within a regional market, or is it something that could be contemplated?
That is not a structure that currently exists, Commissioner Plant. I think what you're contemplating is so our assets sit on the books of Public Service Company of Colorado as an asset for our retail customers. So they fall under your regulation as a regulator for the Colorado Public Utilities Commission. That means that they're in our rate base, and that rate base has a depreciation schedule associated with those individual assets. I believe what you're talking about is if we were to realign or refinance, I think was the word you used, is that would essentially change the depreciation schedule on one of these individual assets. So for example, right now in the CEP and the ERP that we're talking about we've assumed that the asset life ends, so it's no longer than a 25-year depreciation schedule. That was what we were ordered from phase 1 to evaluate in this case. If, for example, you were to change that to a 20-year depreciation schedule or asset life, that would increase essentially the dollar per megawatt hour that would be bid into the market. So the market would pick up some of that difference and that impact, just like the rates our customers would pay, right, on their bills for that particular asset would also increase because of that depreciation schedule change. So it would be picked up on both sides and looked at like, if it were to be sold to the market at that rate, then that would be a revenue credit that would come back against the asset for our customers. And then as it's utilized for our customers and our retail base, that would be recovered through the process that we have with our customers in rate cases and operating expenses.
And ECAs too, I think would come into play, Ms. Jackson. I believe like that revenue that we would seek in this or would generate in this market outside of our system could come back. I believe that would come back to the ECA.
Understood. What I'm trying to get at here is, would it be a potential avenue to say, I'm going to throw out percentages, not with that has absolutely nothing to do with anything, but say 50% of your asset were depreciated at 20 years, and that were allocated to the PSCO customer, and then it's a 40-year asset. So 50% of your asset were then depreciated at a 40-year depreciation, and that was for basically a regional market. Is that a conceivable approach, or is that not something that's doable?
I would say, Commissioner Plant, in my more than 20 years in the industry working on these things, I have never seen dual depreciation schedules such as those. There's always possibilities for looking at things, but I am not an accounting expert. And so that would be something I'd, number one, have to go back and ask our CPAs if FERC accounting allows us to even contemplate doing something like that. So today I would not have that answer for you. My apologies.
Thank you. Yeah, as you pointed out, it's the first utility with a zero carbon goal. So you're going to have some firsts, I would imagine, that come down the pike. I appreciate you taking a look at that. And then as it relates to the renewable resources, my understanding is with the IRA, traditionally, with the tax incentives, PTC has been used on wind, ITC has been used on solar and storage. But within the IRA, there's the capability for that to shift, and you can use PTC or ITC on either of those resources. Has the company analyzed the relative benefits of using one or the other approach with the company-owned assets? And has there been any shift in sort of the traditional way of utilizing those tax credits?
I think the first level answer is yes. We do look at that. That's been in place since the IRA passed, and that became a factor in our bids. I don't know that we've had cause to move that since we bid the projects.
So you use the ITC for all your solar and storage projects, and PTC for your wind?
I believe so. Yeah, I was going to see if Mr. Tom Janovic wanted to jump in his business development role.
Hey, good morning, Justin Tomjanovic, Public Service Company of Colorado. You know, we are choosing to use the production tax credit for both our solar and our wind projects. And then there's only an ITC for the battery projects. And I think if you just, you know, working with the IPPs as well, you sometimes look at the regions and other things, particularly where we are and the amount of wind that we get. The production tax credit based on the number of megawatt hours we generate is more beneficial than, you know, taking a 30% or whatever would be ITC, because we're able to generate more credits. The same thing is true for us when we have done that comparison between, you know, the PTC for solar and then the ITC for solar. So we've made those decisions for us as a way to sort of minimize the cost to customers as a way to maximize the amount of the tax credits that we can get.
So in the case of utilizing the ITC, does that reduce your upfront level of capital expenditure in terms of, you know, say you have a $100 million project, you would only find, if you have a 30% ITC, you would only finance $70 million of that within the company that would then, you know, be financed out over time. Is that the way you approach that?
So we still would have to pay out $100 million to construct the project. And then we would be getting this, you know, tax benefit that would come in. And I'll hand this to Mr. Eiley on how, you know, we would propose the regulatory treatment for how that ITC and how the CapEx works as part of some of the recoveries that we have for some of our projects that are outstanding.
Yeah, I mean, and then the benefit flows back to the customer when we get the tax credit.
So do you, for example, let's take the 130 example.
Yeah.
You have $100 million expenditure for your capital project. You're going to get 30 million back on the ITC. Do you do short-term finance of $30 million? When that comes back, you pay that off, and the long-term financing for the project is 70 million? Or do you take that 100 million, basically put it into your WACC formula and extend that out for 30 years?
Yeah, so we the way that the tax credit works under these transferability rules is that we would be to maximize the benefit for customers. We'd be selling those to a, you know, a third party, transferring it to another entity who could use that. There's a small cost of that. And then effectively that just reduces the amount of debt or equity that we would have to raise to finance the project.
My understanding was with the IRA, the utility was allowed to take those tax credits directly.
We can take those tax credits directly. But, you know, to just looking at the size of the company and the amount of depreciation and all the projects that we have, we may not be able to see all that benefit at the same time. So there is a market to sell off those tax credits to be able to monetize them sooner for our customers.
But when you monetize those tax credits, that savings then doesn't go into that upfront capital expenditure, because you're, and again, in the $100 million example, you're still putting $100 million into the
Yeah, we're still putting
solar.
$100 million and we're still getting the $30 million, let's say, of a credit back. And there's a lot of regulatory accounting and other types of accounting that goes into it. But in effect, the customers are getting the benefit of that and not paying the full freight. They're taking advantage of those benefits and they're getting it directly. The ITC is a little more complicated when you think about how it all goes, but like for the PTCs, you know, they're currently at 2750 plus escalation. So as those come in and we monetize them, you know, that basically just goes back to our customers to reduce that overall cost. And that's built into all of our levelized cost of energy calculations, is as offsetting that benefit of the credits coming back in. So we effectively charge customers less because we're getting those tax credits, and the rates that we're charging them reflects that.
Okay, and then, and with the PTC, you take that full 100 million out for the entire life of the project because you don't have that investment tax credit that comes up front, right?
Yeah, so for solar and wind, it's like we're getting that every megawatt we generate, we're getting a PTC each year, every minute, every day it's generating for 10 years. And, you know, taking advantage of that to lower the cost.
And with the ITC, you're still doing that 100% cost that you're depreciating out over time, but you're taking that tax credit value and you're applying it in some way back as a rebate to customers or a revenue requirement reduction or some sort of mechanism. Is that what you're doing? Thank you. And one last question, I think. You know, big question mark out there is sort of what happens at this point in terms of tariffs. And I'm wondering if you have looked at least with your projects, is there any kind of formula or something that the commission could use as a guideline? If there's a 10% increase in tariffs to China, we should probably see this percent increase in the costs to the overall project, or 20%, 30%, you know, something like that we could use as a guideline. I don't know if there's any kind of a translation of, you know, percent tariff to percent increase in cost.
I'll kick the question to Mr. Tom Janovic, but at the outset, this is how we proposed stage 2 of component 1. Sorry for all the nomenclature, but it's sort of the second round of receiving relief that's contingent upon a change in federal law, which is exactly what you're hypothesizing. So that second part of stage 1, as we structured it in, that stage 2, that second part of component 1 that we structured into our proposal is meant to address that. And the way that we proposed this was up to 15% across both stage 1 and stage 2 of component 1. But I don't know, Mr. Tom Janovic, if you have a formula or a rule of thumb that you use.
Yeah, I mean, there's obviously easy rule of thumbs to take if you're looking at the amount of your solar. We could run through those kind of calculations and think about it. But if you have an X% increase in your solar, just given the percent the panels are as a total of your purchase of your total capital cost, you know, it's going to have less than, you know, if it's a 10% increase in your solar panels, it's going to have obviously less than a 10% increase in your total price of your project. There's also a lot of nuances on like where you're getting different components from, whether you're, you know, importing something from a country fully as a panel, or you're importing just the cells and it's getting put into a solar panel in the US. So there's a lot of different nuances and ways to think about it, but, you know, there's an ability to think about it in terms of a rule of thumb for at least the company-owned projects. You know, for the IPPs who we talked to about, their math and how they do it may or may not be directionally similar, but maybe not at the same level, just given how they may finance and manage their project differently from us.
Yeah, and I get that there, you know, there's a variety of different variables there that would be introduced into every project. And I'm not trying to like hold you to a number. I'm just trying to get a sense. You know, we talk about a 20% tariff, or we talk about a 60% tariff, we talk about an 80% tariff. I just don't know how that translates, you know, as you said, Mr. Eiley, to a 15%. Where do we fall in sort of the general world in terms of the impact of potential price increases? And along those lines, I'm wondering, as you're looking at your solar projects, do you accelerate, if you see some kind of a change coming down the line, would you accelerate the purchase of those items? And would there be any need for any kind of authorization for acceleration, at least to initiate some of these projects under the wire prior to any potential tariff changing?
I don't know, yeah. I was weighing whether that's more Ms. Jackson or Mr. Tom Janovic, but Ms. Jackson has signaled.
Yeah, so for the record, Alice Jackson with Public Service Company of Colorado. This is actually probably a divided question between Mr. Tom Janovic and myself. What I will tell you is that yes, we have proactively taken actions to make sure that we have lowered the risk for projects over the long term, and you're seeing the benefits of that in some of the highly confidential information on the pricing associated with our own projects. In addition to that, though, Commissioner Plant, the one thing I would say that is impacted is by accelerating some of those purchases, the number that moves is not just the dollar amount on that particular component, it's the AFUDC, the allowance for funds used during construction. So as you put those larger dollar payments out earlier, you have longer carrying costs before the project is in service. So when we talk about the impacts of AFUDC on the overall capital investment in the project, that is where the commission is going to see some numbers move, right? As we have to change the cash flows associated with the project due to those early expenditures and outlays earlier than expected.
Understood.
The only thing I would add there is, I think any prudent, us as a company or any prudent IPP is constantly thinking about these supply chain risks and is looking at how they can accelerate things or do things differently to, get in under the wire, sort of as you're describing there. So something, particularly with the election the past couple of days, as we're trying to understand things, we're beginning that process of understanding what, if any, levers do we have on our supply chain to mitigate risk for us as we're going forward.
Appreciate that. And if you can communicate any of that to the commission in terms of actions or things that we need to consider in order to facilitate that, I appreciate it. Mr. Chairman, I have no further questions. Thank you.
Thank you, Commissioner Plant. Commissioner Gomez. Well, let's just check in with the parties for a second. Ms. Keene, do you need confidential status for your cross of Ms. O'Neill or Mr. Neal?
I do not anticipate needing confidential question on that. I did have a question regarding the confidential period for questions of PSCO. Should I raise that now?
Sure, but you don't have any cross reserved.
Correct. Rather, the subjects that in particular staff mentioned, that was a subject of their cross. Recognize this is super awkward, but just sort of trying to balance it. We don't want to be exposed to anything that we shouldn't be exposed to, but to the extent that they're going to be discussing things that could be specific to bid 11, we do have access to that. I don't really know how to manage it. Whether, if there's any of those, we could come in at the very end of that period, or if in the transcript, we could have like more targeted redactions so that we could still have access to that. So recognize it's not an obvious or easy question, but just did want to flag to make sure mainstream's interests aren't impacted.
Let me go to Mr. Kide, then I'll come to you, Mr. Larson. Mr. Kide, does your confidential cross of the company involve Mainspring and bid 11 or not?
Yes, it will.
And will it involve other issues or just Mainspring?
It'll involve other issues as well. So I will be asking questions to the company about information they provided. Some of that is Mainspring, some of it is other projects.
Mr. Larson, I guess what I'd suggest is have Ms. Keene not on the phone, not on the line during the confidential information, and then perhaps you could work with her to figure out, what was discussed. But go ahead, Mr. Larson, did you have something you wanted to raise?
Well, I mean, the only other architectural way to maybe handle it would be to have Mr. Kide handle his mainspring questions first. Ms. Keene can be in the session. Upon the conclusion of those questions, Ms. Keene could exit the room and we could continue with the remainder of the highly confidential session.
I wasn't clear that worked for you, Mr. Kide. Does that work for you?
If you just indulge me for a moment here, look at my notes. I think it actually would work better if Ms. Keene came in at the end, if that's possible, of my questions.
It'd be better if you could do it up front so she could drop off.
I can do it up front. I can do it up front as a service to you all. Sure.
All right. Appreciate it. And,
okay.
And are your questions to the mainspring panel, are they highly confidential or not?
I don't know at this time. I don't know. I can't tell you at this point.
Would you be willing to maybe do your questions to? No, that's not all right.
Well, let me.
Yeah, if you could figure that out over the lunch break, that'd be great.
Yeah, I think what I'll try to do, Chairman, is I'll try to find a way to do it all public on mainspring if we do it, and I'll report back after the lunch hour.
All right. Commissioner Gilman, you want to get started? We probably only have 10 minutes. I'm gonna need to have a hard stop at 11:55. I think we're doing good. I think we're gonna finish this afternoon. No matter what, you want to just take a lunch break or you want to get started?
Yeah, I mean, I definitely have more than 10 minutes, but I'm happy to give you 10 minutes and then we'll just break for lunch if you want.
All right. All right, yeah, get started.
Okay, excellent. Good morning, everyone. I can't recall who was answering the question with Commissioner Plant, but I just wanted to follow up quickly on a question on the treatment kind of ITCs and PTCs as it relates to, I think, the cost of the project that gets rate-based. I'm not quite understanding if there's any differentiation there. So if you were to take the ITC, I think as Commissioner Plant was getting at, let's say for an $100 million project and you get a $30 million ITC, are you saying that the rate-based amount is still the $100 million gross cost and the $30 million is treated elsewhere?
In essence, I think that is what we are saying. So you'd have the $100 million capital investment on the books as a resource, as an asset, and then you return either the ITC or the PTC back through other channels. So in effect, the customer gets sort of a net experience. And it's not necessarily like I guess where I was maybe struggling with the construct a little bit is it's not necessarily on a project basis. I mean, the project would enter our books, starts with the ECA, gets rolled into base rates typically, and then the ITC would be applied against the overall revenue requirements of the whole company, or reduction of the overall revenue requirements of the whole company. So we don't do little LLC, not little, but project-based LLCs like IPPs do. It's all kind of into one set of books.
Okay, but when you take the ITC, it is related. I mean, the amount that you're getting is related to a specific project and its specific cost, right?
Sure.
Okay, but the gross amount gets rate based. Is this historically how the company has done it?
Mr. Tomjanovic?
Yeah, so this was the first project that we brought to you for this was the Rocky Mountain Solar project that I received this approval recently. I need to just look up how we discussed it and talked about it in that case. So if Mr. Eiley is okay with it, we could perhaps identify that and answer that question after the lunch break.
Yeah, that would be helpful. I think part of my main interest here is in understanding the company's intent and pricing based on accepting the PTC and to understand, is there really any difference in what gets rate-based or in how customers kind of see these costs flow through? Because understandably, there is some netting if you get the tax break coming in, yet customers are paying whack on that extra project cost that is being compensated, right? Okay. Yeah, any more clarification you could give, maybe on redirect or however that works would be great. A couple questions. What time do we have to end, Chairman? I just want to.
Yeah, I'm
make sure I
thinking
get
like
you.
5 minutes. Do you
Okay.
want to? It's
I got a couple.
up to you, but it's
No,
I gotta stop at 11:55.
I like to make good use of our time. Okay.
Right.
I have a couple questions on the selective catalytic reduction system, or SCR, as it relates to bid 989. So I believe the main purpose of the SCR is to reduce emissions from the plant. Is that an accurate overview?
I think that's the entire purpose, and specifically to reduce NOx emissions.
Okay. Yeah, my next question was specifically what types of emissions are reduced by the equipment?
That's a specific emissions retrofit that reduces NOx emissions, so nitrogen oxides.
Okay. Does it also reduce other hydrocarbons and other emissions as well?
HCs, I don't know that it does. You know, when we think back like a traditional coal plant, you would put a scrubber on, which is not an SCR, and that would reduce sulfur. The SCR, the selective catalytic reduction, is for NOx, and then you have a separate technology for mercury reduction. So it's really focused on NOx. I think the HCs are controlled generally by other methods than that, you know, combustion controls and that sort of thing.
Okay. And as it was bid in the phase 2 of this proceeding, the proposal included the SCR, correct?
Yes, it did.
Okay. So I'd like to understand a little better, absent the SCR, how would the plant be viewed differently by air quality or other like emissions regulation and permitting, as it relates to that asset and its operation?
Yeah, there's probably a few facets of that. So we bid it with the SCR, and at the time of the bid, it was done to be a bit on the conservative side to make sure that we weren't entering a low bid and then discover we needed the SCR at a later stage, which creates an awkward situation where your bid is increased. So we bid it with the SCR, thinking we needed the SCR at the time. When we looked more closely into the permitting requirements, my understanding from the permitting specialists here, who have deep experience getting units permitted with the CDPHE, is that we don't need the SCR on this unit as we looked at that more closely in the later stages of the project development. In terms of some of the advantages or disadvantages, it's the units don't run a whole lot, and so I don't know if I have the tons here, but the difference in sort of annual tons is not huge between not having the SCR and having the SCR. Not having the SCR requires a little bit lower of a capacity factor ceiling on the unit without it because of the permitting. You're permitting it with a lower capacity factor or lower annual generation. But it also, just due to the technical aspects of this, without the SCR, the unit can start up faster. It can start up and cool off more easily. You have a bit lower O&M cost because you're not buying the catalyst, which is part of the selective catalytic reduction. So you don't have to add capital for the catalyst storage and that sort of thing. You have to buy catalyst to supply an SCR through the life of the project. So you have a bit of savings there. But really the compelling one is the advantage on ramping. And as we looked at more closely a system with the amount of variable renewables that we have, the ramping advantage struck us as fairly interesting. We didn't think we would be near the capacity factor limit even without the SCR. And I think the numbers we had was about a 12% capacity factor limit. And Mr. Landrum may be able to say a little bit more on this, but coming out of the model, we don't think that unit was running over 5%. So we thought it was reducing the ceiling on something that was a ceiling still higher than we would use. So we thought this was a fairly valid way to try to reduce customer costs on this unit.
And just for the layman, having to operate at a lower capacity factor just means you're not allowed to operate the plant as much.
As right throughout the course of the year.
And that was my next question. Are those restrictions, Chairman, you want to go?
Yeah, I think
Okay.
if it's okay with you,
Yeah.
let's break for lunch and come back at 1 o'clock, and we'll keep going with the public session with you, Commissioner Gilman. And thanks for being efficient with time. So anything before we break for lunch? All right.
Nothing from the company. Thank you.
See everybody at 1. I think we got critical mass. You want to go, keep going, Commissioner Gilman?
Sure. Do we have Harriet back with us?
Oh, good point.
Okay.
Yes.
Great. Okay. Good afternoon now, everyone. Mr. Eiley, just as a follow-up on our previous discussion on the SCR device for bid 989, I'm curious if the operating restrictions on the permit without the device are always in aggregate, or are they ever situational based on weather or temperatures or any other factors?
They're based, it's an emissions limit on NOx emissions that's on a rolling 12-month average.
Okay, so at all times a rolling 12-month average.
Right.
Got it. Okay. I'm curious when the company reached the conclusion that the SCR device was not necessary.
It was while we were developing the project in more detail, and it became a question as to whether we should go forward with that or not, really late spring, summer, as we were contemplating some of these potential cost increases and how to manage that.
Okay. And then I was just curious for any additional information or details on the air permitting process with the Colorado Department of Public Health and the Environment, including the timing of that permitting process, and the company's claims that you would have to submit a permit in fairly short order here.
Yeah, my understanding is it can be about a 6 to 18 month process to obtain those permits. They have to do unit specific air modeling to account for the pollutants that the unit will create and understand how that impacts local air quality. So that's where that more situational impact is analyzed. So yeah, my understanding it's about 6 to 18 months typically, and it just kind of depends on the workload down at the CDPHE as to when to get that.
To your understanding, does that timeline change based on whether or not the unit has certain pollution controls?
I don't think the timeline changes. It's more that we need to submit it one way or another. It's hard for them to consider the permit both ways, is my understanding.
Okay. New question. I think Ms. Jackson will answer this because she answered it last time, but I wanted to ensure we rounded out and understood for all of the thermal resources. What is the most up-to-date estimate of online time for all of the thermal resources?
Yeah, so when we look at bid number 0989, and my apologies, I have to look at a chart because I know them by name, not by number. So I'm trying to translate and get the numbers correct here. So for bid number 989, that particular project, we are looking at a in-service date that is prior to June of 2027. So right now that's in that May timeframe, May 2027 timeframe. The current in-service date for project 997 as a standalone is we are also trying to align that around the early summer of 2027, but with some of the delays that we've had on that project, there is some risk that that would come in later in the summer. And so that we are trying to mitigate those at this point in time so that it doesn't fall outside of that summer period. Or bid number 1000, which includes the 2 units, which is the unit 997 plus another one as a combined bid on that one. The first unit that I was just mentioning, the 997, same answer. On the second unit, there is a delay of approximately 2 months between those in-servicing dates. And so that would fall, if it is delayed, it would fall just outside of summer. If it is on time for the first one, then we'd probably be middle of summer for that second asset, is what we were talking about before.
Okay, and what about for bid 11, to your best understanding?
Bid 11. I don't have bid 11 on my list.
It's not well, it's a BTA, not being developed by the company.
Oh, is that the, oh, I see it. Okay. Mr. Tom Janovic may know more on that one. And so this is the mainspring one, Justin.
Sorry, Justin Tomjanovic, Public Service. I need to just look up that in-service date, or I know we have folks from Mainspring on the call that may be able to address it later. I believe it's, I have to just double check the in-service year.
No worries. Why don't, ideally we could either cover it with Mainspring when they're up, or you can cover it with Mr. Larson when he gets to you. Let's see. I was curious, maybe I'll start with you, Mr. Eiley. When did the company first identify the resource adequacy issues that we're hearing about now in this proceeding with the request for additional resources outside of what was identified in phase 2?
I don't know if there was a single recent point on that. We've had sort of ongoing concern over it, and I view what we brought in this proceeding as sort of the third element. We had a resource adequacy 1 action, a resource adequacy 2 action. The resource adequacy 1 action was the Thunderwolf and Neptune expansions. Resource adequacy 2 was extending some PPAs that most 3 gas, I think it's 3 gas units and then a wind unit. We brought all those to you over the last, I don't know, two years roughly to the commission for approval. This continues to go on. We've been actively scrutinizing that need, and Ms. Jackson may be able to comment on that further, but I've been involved in, basically weekly or bi-weekly sort of sessions to, determine what could be done about this. And through those sessions, that's where the idea of the Plains End extension came into play.
Okay. And when did Public Service first enter into a PPA with Plains End?
It's nearly a 20-year-old power purchase agreement. So I don't know if Mr. Bornhofen has that agreement either well memorized or at his fingertips, and it runs through April of 2028. So I'm guessing that's a 2008 power purchase agreement. I think it probably arose out of the 2007 resource plan.
Okay. So the company provides an alternative proposal with some proposals for commission findings in which you describe that, quote, for the purposes of any future cost to construct PIM calculation, the market dynamics, if established by the utility to have cost impacts on the project compared to the baseline, would be considered extraordinary circumstances. Does that sound familiar?
Yes.
Can you clarify for me what the company means by market dynamics?
Yeah, we might have provided a better record with some more specific listings, but I think it's the issues that we've tried to elucidate in our background to this case. So it's things like supply chains, general market shortage conditions, the heightened demand increases that we're seeing all over the market and in the Western region. It's really the factors that were in the kind of opening introductory chapters of my direct testimony. We want to be able to, we're making the case literally here for those factors to be considered and argued for a price increase. We're seeking that finding or decision in this case. Absent that, our fallback is that these same factors, these same sort of background factors that have heightened pricing pressures for here we're talking about component 2, so for the thermal units, those can be cited as eligible extraordinary circumstances as we argue for those increases in a CPCN, where they can be fully scrutinized.
Okay. Do you have any other place I can refer to where you have kind of a more robust description or guardrails or boundaries about what would be considered part of market dynamics?
I don't know if we had an explicit list, but I would say it would include supply chains. Here in component 2, it would be specifically turbine availability. I think there is skilled labor involved and market rates for labor, delays that create AFUDC increases. Ms. Jackson may have thoughts on this as well, potentially, based on your project development experience here. Or Mr. Tom Janovic.
I'm happy to help. So Alice Jackson, Public Service Company of Colorado. Mr. Eiley did a good job of describing some of the major components. Market pressures on demand from a supply chain perspective have changed the cost of materials for people like GE to manufacture the turbines. And so there have been substantial changes in the cost of that equipment, as well as the labor costs are another major driver of the cost changes. Also, because of the supply and demand in the market for major components of these projects, the vendors are requiring earlier payments at larger volumes. And so that does impact the AFUDC, so the financing costs for the project. On the labor side, there's also a logistics costs that are increasing. They're a smaller component of the overall project cost, but they're going up pretty dramatically. And so there's a variety of different areas, but they fall into the 2 categories of the generation asset materials, and namely the balance of plant activity, so the actual construction and labor associated with it.
Okay, thank you for that additional detail. Mr. Eiley, on what schedule does the company anticipate submitting CPCNs for each of the company-owned resources within the portfolio?
Yeah, that's a bit of a dynamic calendar. We submitted and you all approved Rocky Mountain Arroyo already, so that one came in. The next round is potentially as soon as next week. And Ms. Jackson and I have been discussing this, so your memory may be helpful here, Ms. Jackson. I believe that's a set of wind projects next week. We are cognizant of the fact that the thermal CPCN, depending on how this proceeding concludes, the thermal CPCN may be a bit more complicated. We're looking at the end of the year for the thermal resources on that. And I would welcome any corrections from Ms. Jackson from her impressive memory.
You are spot on, Mr. Eiley.
Okay, so we should expect, based on your plans right now, to see CPCNs for each of the company-owned projects before this phase of this proceeding concludes. Is that fair?
I'm sorry, before the which phase?
Well, this phase, I don't even know what phase it is. This is like the 19th inning. So whatever we're in right now.
Yeah, I'm struggling to remember when we expected or suggested this one would conclude, but again, we're looking for the wind CPCNs as soon as end of next week and thermals by the end of the year is our goal.
And is your one question, 1 second, Ms. Jackson, then I'll have you answer too. Is your best estimate that all the wind projects will come in one CPCN and all the thermals in one other?
Thank you for asking that, because I believe that there is the one wind project that is later than that. It's the one, I don't know if we're using the name yet, but I think it's bid 1061 that had viewshed issues with the Sand Creek.
I think that's 1029.
Yeah, so sorry, 1020. That. Thank you. Yes, it's and that one may be just a bit later. I don't know, Ms. Jackson. You look like you were coming in on that.
Yeah, so these projects, so right now the 1015 and 1024 we expect to be filed next week, is the anticipated filing date on those, as was mentioned by Mr. Eiley. 1029 would shortly follow that sometime, we believe, in the early December timeframe. And then bids 0989, and right now the difference is either 997 or 1000. Those would follow a decision of the commission for the request that we have here for the modification for the replacement of 0235. So that we are trying to hold. What I will tell you is that there's urgency around all of these to be filed, because in-service dates and the processing and being able to start construction is of paramount importance. And so we're trying to bring them as expeditiously, but respecting the process that we're in here as well, in order to move those forward quickly.
Okay, thank you for that understanding. Mr. Riley, so it sounded like from your testimony before, the company is in talks with one company for hiring that company in the independent auditor role. Is that accurate?
At this time, that's my understanding, and Mr. Landrum's been leading that engagement with that market.
So either of you, how did the company identify and select that specific contractor as the most appropriate?
I can answer that, Commissioner Gilman. This is John Landrum from Public Service. Really, it was just an ad hoc call to some of the companies that Excel is used to doing business with that would probably have technical expertise in this role. Both of the people that we reached out to are national names that are recognizable in the auditing space. Ultimately, we are proposing to consult with staff and UCA, very similar to the way the ECA independent evaluator is selected, to get a consensus decision on whether the one of them pulled out, by the way, so we're down to just one company that we've had prior conversations with. But we'll get consensus with them that's appropriate to move forward with this particular company. And if they disagree, we'll search for some other ones.
Okay, so you envision including staff and UCA in that kind of company selection portion of the process. That's accurate?
Correct.
So in terms of the actual contracting with them, and then when they're conducting their work, would the company be responsible for communicating with and directing that work, or would staff, UCA, or any other parties have any role in that work?
We haven't really clearly laid that out in any of our filings or testimony. It is somewhat fluid. I think our expectation is it would be managed similar to the way the independent evaluator is in ERP proceedings, where the company would probably have the most direct contact with the independent auditor. But unlike in those proceedings, there would be even more independence, because the company would essentially be a customer of the independent auditor, just like the PPA providers are. So we would manage contract administration, and frankly, that's probably about it.
Yeah, so that got to part of my next question. In your proposal, this independent auditor would review, in addition to PPAs, the company's owned and BTA projects, right?
That is our proposal. That's correct.
Okay. Do you have a conception who would create the criteria or matrix or whatever we want to call it at this point, by which the independent auditor would evaluate what types of costs should be considered and what increases are reasonable?
We would be part of the consultation process with staff in UCA. We laid out some kind of high-level guidelines in our testimony already, but we would certainly clarify and agree upon a scope of work as a formal contracting document with consultation with those two entities.
Okay, and you anticipate a scope of work would include some formalization as to how these decisions would be expected to be made?
That's correct. I mean, at the end of the day, we're relying on the professional expertise of the independent auditor, but we would certainly provide guidelines as to what things we think would be legitimate and what would be not. For example, just increasing profit margin is a clear not necessarily in scope, and other than that, we would try to let the independent auditor make their own recommendations and decisions.
It would be interesting to see someone submit that as a case. And then, Mr. Riley, just back a little bit to make sure I understand the timing of what you all see going forward from here in your proposal. If the independent auditor has done their work at the end of January, which you laid out in your discussion with Mr. Detsky, and then you've characterized, you think then their recommendations come to the commission for some sort of up or down or modification or something. When do you conceive that the commission would give the final go ahead on those pricing changes?
I am trying to recall our schedule. We laid this out, and I'm sure it was in my direct case. We had a process here, and I don't want to misspeak on that actually, but it is laid out in the direct case down to the day detail, and I apologize, I don't remember what
Okay.
it is.
Okay, but that all matches what you discussed with Mr. Detsky in terms of the independent auditor's
Yeah.
timeline,
And it
which I
kinda
think he
concluded near the-
astutely pointed out only gives them 30 days to evaluate more bids than that.
Yes.
Okay.
Yes.
Just want to talk through contracting with PPAs for a bit. In your testimony, Mr. Riley, you had indicated that developers about 2/3 of the bids in the approved portfolio and the backup bid pool stated they would require some price relief. Does that sound familiar?
Yes, that's roughly right.
And it's my understanding you don't have any signed contracts at the moment. Is that correct?
I believe that's correct, and I believe we're near finalization on several.
Okay. Just curious, on some of the timelines for the contract negotiations. Do you have any insights into how many people within public service, both in-house and out, work on the contract negotiations team to move these forward?
I think that's a great question for Mr. Bornhofen, as he leads the team who does that negotiation work.
Yeah, I can take that. Thank you. This is John Bornhofen, Public Service Company of Colorado. We have about a dozen folks on our team. To be more specific, we have about 8 folks on our team. But we work with various teams throughout the organization. Our operations teams, our risk teams, our legal teams, and a half dozen others. So primarily, less than 10 folks lead those efforts, but probably across the organization, there's 50+ people that participate in those negotiations.
Okay. And how does the number of employees or folks working on that team compare with like the contract negotiations team for prior ERPs, like the Colorado Energy Plan?
It should be similar because it's the same team that's going to be doing, it's the same team for all of those plans. So it should be similar.
Are they the same number of PPAs that you're negotiating with?
Not the same number. No, the volume that we've had here during this solicitation has been greater than prior solicitations.
Okay, so you have more contracts you're negotiating with the same team as in the previous ERP?
That's correct.
Okay. Does the company have any internal standards for how long it takes to turn around a contract with each round of revision?
For each revision, not necessarily. It's going to be dependent on what's being contemplated during that revision, and so it can vary. It can be a day or two to several weeks, depending on what's being contemplated and who all is involved. But in terms of coming to conclusion of those negotiations, we try to set goals in our negotiations. I don't think we have a set timeline. It's really going to be dependent on each solicitation.
Okay. For each round of revisions, you indicated it could take from 1 day to several weeks. I was curious, is there an upper limit that the company tries to set on your responsibility to turn around a revision?
Generally speaking, it's as quick as possible on every revision, because we hope to be, our goal is to try to get these revisions done or these negotiations done quickly. So in each case, we're trying to get them turned as quickly as we can.
Okay, but no limit.
No limit.
Okay. And then what would be a typical goal for the totality of the contract negotiations that the company would set?
It's going to vary depending on the technology, and it's obviously going to vary based on the two parties and how cooperative those two parties are, how for lack of a better word, how sophisticated those negotiations are. And so if I could say on the low end around 90 days on a very simple negotiation, let's say, for example, it's you're only negotiating one single PPA, and it happens to be, let's say, a solar PPA. on an existing site or something like that. That would be a very simple or more simple negotiation, maybe 90 days. But if you're trying to balance several negotiations simultaneously, or if you start changing into technologies, and I'll give you another example. If you're going into gas or battery or solar plus storage, those are much more complicated transactions, much more complicated negotiations. And so those can be much longer. And I'd say 6 to 9 months on those is a typical timeframe.
Okay. Do you have any concept for me with regard to the contract negotiations kind of in their totality for this ERP, how that would compare to the length it's taken for the totality of contract negotiations in prior ERPs?
I can just give you an example because we have ERPs, IRPs throughout all of our jurisdictions. And in one of our other jurisdictions, we had it only resulted in a single IPP being selected and a single IPP moving forward through negotiations. And that took about 4 months to get that transaction closed. And again, in that case, that was a solar transaction. And another one of our jurisdictions, which we just concluded on a ERP in the last year or two, we had 2 transactions come out of that solicitation. And that took us about 6 months. And those were more complicated. So those were gas and battery transactions. So those obviously would notably take longer.
Do you have any understanding on the totality of the length of negotiations for most of your PPAs for this ERP compared to prior ERPs in Colorado?
Not in specifics, but I would say generally speaking, this one has taken longer.
Okay. Okay, this one might go back to you, Mr. Riley, but I'm not sure. So as I understand it, there are numerous bidders that the company has that are willing to move forward without the component 1 price relief. Although, as I understand it, some may now be looking for it, or many may be expecting the component 2 price relief. Hopefully I'm using the right terms. Correct me if I'm using the wrong. There's like buckets and plans and components and things. But anyway, there are numerous bidders who have not indicated that they need price relief in component 1, although I understand several are still interested in the component 2. So I want to understand from the company's perspective, what incentive would those bidders have to move forward as bid rather than going forward and trying to request increases, despite the fact that they've said they're willing to move forward at the bid price?
A couple of things. First, in the nomenclature that we invented, component 1 has stage 1 and stage 2 under it. So just for clear record purposes, I'll start there. I'm not there. There were some who weren't seeking, and stage 1 is now, and basically, this immediate process by New Year's Eve and then early next year. Stage 2 would be set near the end of 2025, just to clarify that. There were some bidders who didn't claim to need a stage 1 increase. It was a broader set of bidders who, almost universal, I believe, Mr. Bornhofen can correct me, I think nearly every one of them really wanted the stage 2 increase. And there are maybe a couple of incentives on that. First of all, you may have advantages in being able to move forward with your executed contract if you were not seeking the stage 1 increase. You may be able to finance things that you're trying to do to advance your project. I would suspect that would be true. The way that we structured this proposal, and it's a bit in the nuances, if one entered stage 1 and then later sought a stage 2 increase, we set it up that it would be a stage 2 increase. If they're seeking a stage 2 increase, but the change of law was such that there would actually potentially be a decrease. And I know that sounds unlikely, but it's happened before. Tax Cuts and Jobs Act came in and reduced tax levels. But if that should happen in stage 2, they would be subject to a bidirectional type of proposition. If the change in law increases project costs, they can get an increase. But if change in law decreases project costs and they have entered stage 1, they would be subject to a potential decrease in the project costs. And we structured that such that if you enter that stage 1, you're subject to what we call the bidirectional effect. If you do not enter stage 1, you are not subject to that bidirectional piece. So there's a bit of an incentive, there's a bit of a risk to entering stage 1 if the change in law is such that costs of your project are deemed to have decreased. And that's something that can be triggered by the company, by the commission itself, or by trial staff. That determination on a federal change of law under stage 2.
In what time frame do you anticipate this stage 2? Thank you for correcting my nomenclature. I feel like in every proceeding, you guys make up new tiers and things, and I have to keep them all straight. Under what time frame do you anticipate that stage 2 would occur, or by what time of enactment or implementation of a change in federal law would that still be considered and be applicable for this bidirectional change?
We set it up so that it was actually fairly similar to what we're looking at for stage 1, which is that by the end of 2025, this determination that a change of law had occurred would happen. And then the parties would bring their requests by the end of 2025, and then the calendar would look very similar to the one that we've discussed for 2024 going into 2025. You'd have the same thing in end of 25 and 2026. I'd have to look, but I believe if there was a change of law earlier, we could start this process earlier. But we thought letting that calendar year 2025 play out was a suitable period to evaluate things like changes in tariff.
Okay. And then I know, we know what we know now about the current national politics. So given the current political realities, what are the most likely circumstances in which you would see a downward adjustment for stage 2?
If there were applicable tax reductions that could occur for stage 2, that could be a downward pressure.
Applicable tax changes on like corporate tax rate?
Yeah. Tax Cuts and Jobs Act was the precedent for this. In fact, in that resource plan, we did a rebid process. We refreshed all the bids in the middle of that phase 2 because Tax Cuts and Jobs Act had occurred. So we priced in the middle of that phase 2. So that's probably the most obvious example. I mean, I'm starting to reach into the realms of, I don't know, the realms of the imagination on politics. I mean, could there be an ease of permitting or something like that? I don't know if that's a possibility. I certainly would concede that an increase is more likely than a decrease. But we did attempt to create an incentive to stay out of stage 1 if you didn't need it.
Okay.
There's also that IA process, right? Like they have to prove they need the stage 1 relief through the IA and through the commission. So if you don't want to do all that work and take that extra time, that's an incentive to proceed. Okay.
And you had kind of referred to previously a change in project costs due to the change in federal law, but if a corporate tax rate changes, that's just kind of an overall change, or how would you relate that directly to project costs?
The projects might face, in theory again, they might face a lower amount of federal taxes, and therefore their projects would need less revenue to earn the same return.
Okay. You referenced previously a commission rule dictating negotiation timeline with IPPs. I forget who you were talking to. It was this morning. Do you recall that?
Yeah, Mr. Detsky, I believe, and I had that exchange.
Okay. I assume that there you were talking about Rule 3613I, which essentially states the utility must complete the competitive acquisition process by executing contracts for potential resources within 18 months after the utility's receipt of bids in its competitive acquisition process. Does that sound like what you were referencing?
Yeah, yes, it does, and thank you.
Yeah, no worries. I'll acknowledge the company asked for multiple delays in the phase 2 process related to the 120-day report. Given all that, I'm curious what the company's operating assumption is regarding this rule and the deadline for you all to execute contracts for approved resources.
Well, like, when did it start?
What you perceive as the deadline that would be dictated by that rule.
I am not sure I know that for sure. Obviously we had the decision earlier this year. I would presume it would kick off 18 months from that deadline. I'm just trying to remember the exact date that we got our final phase 2 order. It would be 18 months from then. We might be able to supplement the record on that. I don't know the exact date from that.
Okay, so as opposed to the utilities receipt of bids in the process, you perceive the beginning of the 18 months to be the phase 2 decision?
Oh, I apologize. You're right. I think it's from the receipt of bids, then 18 months.
So bids were received, I think, in March of 2023. That's my understanding.
Yeah, that sounds right.
Mr. Larson?
Yeah, Commissioner Gilman, just to help fill this in, we have sought a waiver of that rule as part of our motion to initiate the CEP delivery plan. So that request for relief is pending before you all now.
Okay. Maybe you can hotline me to the answer then on what the company's perceiving as the deadline on which they should complete the contracts.
We are running down that in the motion right now. I can come back to you shortly.
Thank you. Okay, just a couple more questions on ISOC. So the company's put forth a proposal to increase the incentives under the interruptible service option credit, or ISOC, to encourage more DR capacity. Does that sound accurate?
It is.
Do you know how many megawatts nameplate and accredited are currently in ISOC?
Oh, offhand, I don't. I know that we had Mr. Landrum had been asked some questions about the line 22 and the LNR table, which was the totality of demand response. And I believe he has that set of some subcategories of demand response there. So maybe Mr. Landrum can help me.
Sure, sure. Commissioner Goodman, is John Landrum, Public Service. Currently, like by 2024, for example, summer 2025, ISOC is about 210 megawatts of nameplate capacity. Our proposed resource adequacy study that's under consideration in the JTS gives that program about a 33% ELCC. So 33% of 210 would be what the accredited capacity would be currently.
Okay. Sorry, you said that's using the ELCC from the JTS or from this proceeding?
So as of right now, until the JTS is approved, demand response is treated as a load modifier. So it's on the load side of the LNR table. And in addition, it does not incur a reserve margin because it's on the load side. It's a reduction in load. So to do that equivalent calculation under today's paradigm, it would be approximately 210 megawatts times 118% would be a net effect on the short position.
Okay, sorry. So, okay, so as it is in this ERP, you're saying it would be essentially counted because it's a reduction in load, counted as a negative at 118% of the 210 megawatts?
Correct.
Okay. And then what is the target for new either nameplate or accredited capacity under the new incentive structure?
Not an expert in this area. Our customer solutions team would be probably better to answer that. In conversations, they believe they might be able to get 10 megawatts of accredited capacity or so out of the existing customer base or customers that have decided to leave the rate because of the lower incentives, et cetera. But I'm not sure if any other witness has better information than I do.
I don't have a lot more. Our proposal was essentially to raise that rate on ISOC from or yeah, it's not AC, so 1127 to 1597. We thought that could get about an additional 10 megawatts out of this program.
Okay, and will that increased rate be offered to current ISOC customers as well as new?
I believe that's exactly where they feel that there may be some additional demand response to be found.
You mean that existing ISOC customer would just up their capacity in the program?
Yes, my understanding is that they've been less interested in participating in the program with the 10-minute notice and the additional incentive if they receive that under this proposal would make them more interested in participating with the 10-minute notice. And so the estimate is that we could get about 10 megawatts incremental.
Okay, I'm a little confused. Are those 10 megawatts from new ISOC customers or 10 increased megawatts from existing ISOC customers?
I believe it may be a mixture of both, but my understanding is more the existing.
Okay, so an existing customer is already in and they would sign more capacity up with you because of the greater level.
Yeah.
But they'd get the greater level for the entirety of their capacity. I don't know what to call it. Capacity election.
Yeah, capacity, right. I believe that's the case.
Okay. What alternatives has the company considered related to other demand response offerings to increase kind of uptake and availability of other demand response?
Well, within the scope of this case, we took a look at all of them to kind of see what sort of things might make sense to offer, to bring to this proposal alongside the other resource adequacy solutions. So in the short term, that was the one that was deemed most suitable.
Is there any available analysis where the company evaluated other demand response options?
I'm sorry, I talked over you at the beginning.
Oh, sorry. Is there any available analysis where we could see what other demand response options the company evaluated?
We listed them. I don't know if we've shown you the analysis here. And I don't know that it would be a lot different than what you may have seen in, say, a DSM strategic issues type proceeding. If you're looking for something more recent or specific to this proceeding. But I know we looked at all them: AC rewards, peak partner rewards, critical peak pricing.
Okay.
But I don't know that we had an analysis that we brought to this proceeding per se. It was sort of a, evaluate the programs and see what might be possible, especially in the short term.
Okay. Those are my only questions. Thank you.
Thank you, Commissioner Gilman. Mr. Larson.
Apologies, Mr. Chair. Commissioner Gilman, just to close out our exchange, we sought a waiver of Rule 3613I in our motion. The new deadline would be March 1, 2025. So that was designed to kind of work in concert with the IA process and the potential timelines and deadlines that would occur over the course of that process.
Thank you for the follow-up.
Thank you, Mr. Larson. So I'd like to bounce an idea off the panel, maybe mostly you, Mr. Eiley. For purposes of this question, assume the commission has serious concerns with the independent auditor approach in terms of creating more regulatory process and delay, the potential for further price increases during the delay, and the impact on limited regulatory resources, sort of the concerns Mr. Detsky laid out with you. Further assume that this commission approves for all PPAs and project-specific PIMs the stage 2 change of law language exactly as proposed in your attachment 20, Mr. Eiley. Finally, please assume we've examined every winning backup and supplemental bid based on the bid status update presented in attachment 17 of your testimony, with the goal of getting the most projects online as quickly as possible at the most reasonable incremental cost. So what would you think if we, similar to CIEA's suggestion in their comments, allowed an across the board 1% pricing increase for standalone solar? Let's start with that. without any further verification or process or any independent auditor review for component one, stage one price release. According to the bid status update, again, hearing exhibit 166, attachment 17, this price increase would be sufficient to get more megawatts of solar facilities online, perhaps than even initially anticipated, as long as there is change of law price relief in stage two. So it seems like removing the IA process and going with an across-the-board 1% increase could provide bidder certainty within a few weeks, quickly end this regulatory process, likely get the necessarily solar projects built, at least according to the latest information, and would limit customer impacts. So what do you think? And if you want, we can do this in confidential session and go through it bid by bid. But again, when I look at the standalone solar bids, we can get everything we need and, just say, give a across the board 1% increase in price and be done at minimal rate impact to customers, and not open it up to the independent auditor process and 6 months of delay. So I guess, Mr. Riley, any thoughts?
Maybe one clarifying question. You basically you're removing the IA process for stage one, but then you said assume stage two, there's this change of law provision is approved and is still outstanding.
Yep.
Would the IA, and I don't know if this matters or not, but would the IA be removed from that as well, or?
I don't have a strong feeling about that.
Just trying to frame
I think
up
it's really the stage one process that Mr. Detsky seemed concerned about. It's just let's get these projects built now, not wait till April. And the thing that I'm relying on is this bid status update that basically says we can get, at least for standalone solar, all the projects we need. So why are we even doing anything? And there's a lot of evidence prices went up. So let's do what CIEA suggests, give them a 1% price increase and move on.
Will this be a sequential conversation when you talk about wind and then the thermals, because you only address the solar with your assumption that the 1% might solve it?
I will go to storage next, and then solar plus storage, but let's start with solar.
I don't know if we're prepared to answer on the spot. It's an interesting question. The company's solar projects already have the CPCN, so we're not seeking it for company-owned projects. It's kind of a matter of how you treat the IPPs, as I understand it here.
And we'll see if this Ms. Jackson, go ahead.
So Alice Jackson with Public Service Company. Mr. Eiley, do you mind if I ask a question?
No.
Okay.
Please.
Howdy, Chairman. So I'm looking here at the exhibit that you mentioned, which is, you said hearing exhibit 166, attachment 17, correct?
HC, yeah.
Okay, and I'm going to do my best to ask the question without having to go into the highly confidential, but I'm reading through, and you explicitly pulled out the solar standalone, correct?
Correct.
When I read through the list of the comments for the solar standalone included in here, I see only one that says that they can proceed without a change in their price. Am I missing something in what you are asking?
No, look at, and we'll see if council wants to stop me. So be on your toes, Mr. Larson. I'm looking at bid 474 and bid 782.
Okay.
As I understand it, both those bids are prepared to move forward as bid, subject to stage 2 price relief. And that gives us all the solar really it's more than the solar we've asked for.
You said 474 and 782?
Correct.
What I don't have on here is timing of in-service dates.
$782 is 2027. 474 is 2028.
Okay. Thank you for pointing that out. Appreciate it.
Well, I guess for purposes of this conversation, assuming that my characterization is true, subject to later check, do you have any concerns with just letting these guys go forward without any independent auditor process?
Mr. Tom Janovic has his hand up, as does Mr. Larson.
Yeah, Mr. Tom Janovic.
I'll let Mr. Larson go first, please.
No, the only thing I was going to say is if we're going to look at this table, if it's going to be a better discussion, we may want to do this in confidential session so we can pull this table up and kind of step through it. I think it's challenging to do this, like talking about it amorphously based on the table. I know that's a pain in the neck to go in there, but I think it's going to be a better conversation. That's
All right.
my point of view.
So maybe I'll do this all in confidential conversation, but for the solar plus storage, I think 325, 90, and 190. Oh, sorry, I'm looking at the wrong thing. 149 and 476 are both prepared to move forward without any price increase. So again, the idea would be there, a 1% across the board price increase.
And
then
continued eligibility for stage 2.
Correct. And the same thing on the standalone storage with bid 589, 249, 251, 282, 467, 1085, and supplemental bid 275. All those bids have not requested price increases. So the idea would be to let them move forward with a across the board 1% price increase with no IA process. And if they can move forward, they'd move forward. If not, they can bid on it. Yeah,
so
go ahead.
I was just going to respond on one point that I'm pretty sure we're sure on, which is outside of the HC, we can talk about this one. If you get beyond the backup bids into the supplemental backup bid pool, which I'm rapidly looking at numbers, so we may be doing that or not. We really struggle with the supplemental backup bid pool for two reasons. It raises owed issues, and as these bids weren't even backup bids, you know, it wouldn't be unfair to characterize some of our reach out to them as surprising to them that they still existed as a bid at all. We struggle to think that those are practical projects to bring forward at this point. I think we testified on that, and other parties may have as well in the supplemental comments.
I understand, especially the owed issue, but I think 275 responded in the status update favorably. So maybe we could take that up in the confidential session. I guess for wind, let me see if I can propose a little bit different thing. For wind, assume we cap the increase at 6%, but retain the IA review approach. In other words, we put the PPA and utility-owned projects on an equal playing field. We're both get a 6% increase, and both would be subject to IA review. So basically treat the wind a little different than we treat the solar, the storage, and the solar plus storage. Any thoughts on that?
How is that different than our proposal for the wind projects?
I think it had greater than a 6% increase, didn't it?
Under component one, stage one, I think our projects were the same as the IPPs, which is up to 6.
All right. So maybe the proposal would be to keep the wind as it is. Have just in follow up on Commissioner Gomez's question, have you executed any PPAs to date?
Not quite. There are some nearly done.
And is it fair to say that none of the IPPs have posted credit support at this time, given the PPAs are unexecuted?
Mr. Bornhofen?
Yeah, this is John Bornhofen with PSCO. That's correct. No bidder has put up security quite yet.
Okay. And I guess we can see what Mr. Kruger says, but I think COSA referenced a red line PPA that it provided as part of its RRR filing in phase 2. And I just had one question following up on that. In that red line, and this is for you, Mr. Bornhofen, it may be too much in the weeds, but I read through that red line contract, and one of the provisions, it's section 5.2, required bidders to make all capital expenditures required to comply with any changes in law that reduce capacity or ancillary service value to the company. Do you know if you're still seeking that provision? That seemed like it could be a potential problem.
The provision still remains, but we've actually reached, I would describe it as kind of a mutual agreement on that provision. In other words, where we share the cost of that provision.
All right. So the language that was in the draft Mr. Kruger provided has been modified in a way that you're representing as satisfactory.
That's correct. And on that point, I think we've basically come to mutual terms on most of these negotiations.
Okay. I guess the only other thing that caused me pause was there's like a 5-day notice period for a force majeure event. That basically, if you didn't provide notice in 5 business days, it ended your opportunity to claim force majeure. Do you know if that language is still in there, or has that been modified? And I don't need to know the details if you reached agreement.
Actually, I'm happy to answer that question, but I think I'd rather do that confidentially.
Okay. On Plains End, if we require you in the order coming out of this process to extend the PPA and start due diligence on a purchase, it sounds like that's what you guys were offering in your testimony. Is that correct?
We're not offering to start due diligence soon because we're not allowed to under the contract. It depends on which way we go with that contract. If we extend the PPA, we have the purchase option from 2027 to 2031. We do not extend the PPA, that purchase option is in the calendar years 2026 and 2027.
Any concerns if we ordered you to extend the PPA?
That's what we proposed.
Yeah, okay. Just a clarifying question on bid 1000. If that got approved, would you move forward with that 400 megawatt project with a construction PIM equal to the dollar amount shown on page 5? I think it's of your 17 attachment in a fixed way, or would you be seeking future potential adjustments? And maybe that's also for that confidential session.
Yeah,
we're probably
Mr. Chair.
I'll say this, we're probably going to need a minute on all this.
All right.
And our
Let
ability
me,
to answer today may not be perfect. To the extent you're proposing things that are a proposal or very close to them, that's much easier to align on. Ms. Jackson.
on this one, I'm just asking if the pricing you're presenting is something you're willing to live with or not.
Mr. Eiley, would you like me to jump in?
Yeah, please.
So on bid number 1000, the pricing that is included on page 5 of the highly confidential is the anticipated cost as of today. You know that includes the extraordinary circumstances estimates that we have included in here. We will bring to the CPCN the justification for those extraordinary circumstances numbers, and then we will proceed to construct the project. Upon bringing it to the commission in the rate case, once it's commercially operational and in service, that is the final review of those capital costs and that upfront investment. Those numbers could be slightly greater, they could be slightly less, right, than what those are. We are proposing that the CTC gets set at this number from the CPCN, right, process that we go through, so it'll be set in there. And then it gets reviewed in the rate case whenever the final numbers are in. Does that make sense?
It does. I guess the question I'm asking is, would you live with the number you're proposing today?
This is the best available information we have as today, Chairman, and that is the number that we have before you going into the CPCN. Yes.
Is that?
Are you asking if that's we're asking for it to be updated to that as the CTC?
Yes, I'm asking if you're willing to commit to that as the construction PIM now, and not to be altered unless there's sort of extraordinary force majeure circumstances.
My understanding is that was our proposal in our direct on this issue, and then we had modified that to accommodate some requests from others to where we sit today. So I can say yes to that on this project. If we updated to the CTC, we'd be willing to stick with that on project 1000.
Okay. On bid 989, you talk about dual fuel. Is that fuel oil or hydrogen? What's the dual fuel? I was not clear on that. Do you know?
It is fuel oil.
Fuel oil. Okay. And can I just ask you, what do you really need us to approve? As I read the testimony, it looked like you were asking us to approve the SCR, which is somewhat, or the fact that you didn't need SCR, which seems beyond the ability maybe of this commission on this record. Is it fair to say that what you really need us to approve is that it's okay to move forward with a 12% cap on the net capacity factor? Or are you asking us for approval beyond that?
I think you're getting into sort of a regulatory issue and the fact that it would be CDPHE that would deem it required or not to have an SCR for the permit.
Right, right. And as I read your request, it seems like you're asking us to sort of bless the fact that SCR isn't needed, which gives me real concern on this record because that's the job of CDPHE. So what I'm asking is if we just determine that a 12% capacity factor limit was okay, does that give you what you need?
It may. I think we have to be careful before we commit to that. But I appreciate your translating what could be perceived as something outside of your regulatory lane into maybe something that is. I appreciate where you're trying to go on that.
All right. So if you can just help us know, if you can help us narrow the approval request to something that's more within our realm, I think that would help us consider it.
Mr. Chairman, if I may, our intent was not to get you out of your regulatory lane, but ensure that this commission, and I think it's assuming CDPHE permits this without an SCR, which we do feel confident about, is essentially okay with that movement of the bid from a unit with an SCR to one without it, because we bid it with an SCR. We did it, again, to be conservative and to make sure that we didn't have a surprise add-on if we found out we did need it and bid it without it. So it was better to bid it with it. And we're seeking essentially that a finding that it's permissible from the commission standpoint, that the unit without the SCR is an okay unit to proceed under this bid.
And I think that's a tough ask on this record.
Okay.
Maybe it's I guess what I'm asking is if you can recast it so whatever negative consequences of not having the SCR are perhaps subject to our approval, which I think is mainly the 12% cap on the net capacity factor, and the rest is your business and CDPHE's business. So and again, if you could let us know on that, that'd be great. On Mainspring, if the technology doesn't work as well as everyone expects, who bears the risk of that failure? Is that on customers, shareholders, the vendor? Is it, just who's bearing the risk if the thing doesn't work as we expect? Mr. Tomjanovich?
Yeah, Chair Blank, Justin Tomjanovic, Public Service Colorado. The way that we are approaching this Mainspring contract is very similar to what we brought to you with the Form Energy 10 megawatt battery that we, proposed and got approval for, that I worked on developing. It is a newer technology. We're a little bit, obviously uncertain both about the performance. There could be some performance uncertainty. And then also as companies, we've gotten to know Mainspring for a long time. I think their technology is really impressive, but you just don't know. So what we've done with Form and what we do here is to have not just, the service and the warranty from like a technology vendor, but also making sure there's other warranties and other protections that protect customers in the event that it underperforms. So, we're trying to treat it consistently with the way we've done with other types of technology to protect customers from that underperformance.
And is there credit support behind those obligations?
Yes. I mean, it might have to go into a confidential session to discuss some of the details.
All right. And is it, I mean, maybe I'm not familiar enough with the record, but is it on this record? I know I saw the Form Energy contract and the credit support provisions. I don't remember seeing it on this record.
It was a different proceeding, so I don't think there's anything on this record about
on the Mainspring.
So sorry. Sorry, repeat the question.
Yeah, I mean, on the Form Energy deal, I saw the offtake contract and the credit support requirements. Is there anything on this record about the Mainspring credit support and contract requirements?
No, because we have not finalized the negotiations and some of the technical review to propose a CPCN, which would have all those details behind it.
Okay, so we'll see that in the CPCN filing.
Yes, presuming we complete our negotiations and review of everything, we would come forward with that in a CPCN.
And are there ancillary service, reactive power, black start, or other non-related, non-energy, non-pure energy related benefits of the project?
I mean, by design, I could go into the technical details of that. I need to see. I don't know if it's officially a black start unit or the reactive power, but it has the ability to, operate on a other type of backup fuel that will allow us to restart, just like a dual fuel unit is being used to restart in the event that there is not enough gas, and start to create some of that energy. But it's not spinning mass, so it doesn't have that same spinning mass impact that others. But I can get more details. I'm obviously not the complete technical expert, but I know just it doesn't have the same inertia you get from like a rotating unit.
Yeah. And in the event of a natural gas disruption, it sounds like from the materials you presented, there's backup propane on site.
Yes.
Okay. I guess the last public question I have is, as I understand it, we're 18 months out from the initial bid submission and still haven't executed a signed contract, offtake contract or construction contract. Do you have any advice about a constructive way to make sure we get from here to timely contract execution, monthly reporting? I'll ask Mr. Kruger the same question, but just any advice about how we can make sure this moves expeditiously, given all the conversation about how delay raises cost and price.
Positive signals here obviously help. I mean, the conclusion of this proceeding, Mr. Bohr.
I'm trying to get this done within the next 4 weeks.
I appreciate your enthusiasm. Mr. Bornhofen is, assiduously negotiating these contracts. There's no intent to hesitate on that. These very reliefs that we've been seeking are a big part of what's needed to do a lot of those. Mr. Bornhofen?
I just wanted to say one thing, and just for your peace of mind, Commissioner. The change in law has been a big challenge for these negotiations. And in other words, how are we as an industry going to handle this potential change in law based on the results this week and potential exposure to new tariffs, et cetera. So I feel like once we can get a resolution to that, and hopefully that this commission can provide us that, we should be able to reach final form with a good number of these contracts within very, very short order.
And does the change of law language in that attachment 20 give everybody exactly what they need?
I'll say yes, with the exception of there may be some additional mechanics to that we need to elaborate on in terms of like the dates and such. So we'll elaborate on those provisions. But yes, that language is what we have been proposing.
Mr. Tomjanovich?
Yeah, I'll just add here, Chair Blank, that just given like the election dynamics of the other day, there's a period of uncertainty. And I think, not just quick resolution of this, but flexibility even on the phase 2, because most of these IPPs are probably getting questions from their management teams and investors about, hey, is this still a good project going forward? So I think, like you mentioned, quick resolution here also sends a signal, because as we filed I'm out in the market all the time talking to these developers, building relationships with supply chain and others, sending that signal to the market. We also have a JTP and an RFP in the next year and a half. So within the next 4 years, I think it's really important to send a positive signal to the IPP market now that there is this flexibility. And phase 2, we may have to move things faster, to be honest, if there are some tariffs that come about and that quick resolution. So I think sending that signal is really important for the market.
All right, I think that's all I had. Mr. Larson, what's the best way forward? Do you want to take a break and go into confidential session? Do you want to do public redirect?
I think it might be helpful to go into confidential session, but if we could take a break to I think there's a few things we probably need to discuss as a team before we go into that confidential session. If we could do that, I think at this point, at least, all of my redirects is going to be public. So if we could go into that confidential session, then we could come back out and be in public session unless and until there were questions of intervener witnesses that implicated confidential materials, if that approach makes sense to you.
Yeah, that works for me. Ms. Kunkel, anything you need from all of us to go in the confidential session?
It's Casey today.
Oh, sorry.
It's okay. No, I guess my only question is, well, actually, no, never mind. It will probably take me about 5 minutes just to get everything set up and go through the list of people. And then right at the beginning of the session, I'll probably ask Mr. Larson to look at the list and make sure there's no one I missed that's not supposed to be here. And I would just ask that anyone that knows they're not supposed to be here, head out of your own accord, please.
So, Ms. Keene, I think we're going to start with Mr. Kide when the confidential session starts. I'd propose at 2:30. He's agreed to start with Mainspring, and then as soon as he moves on, if you could drop off, that'd be great.
Understood, thank you. And just to confirm, because my witnesses have also filed the same NDAs, just confirm that they are allowed to stay as well.
Mr. Larson, is that all right with you?
Yeah, no problem with that from the company's perspective. Thanks for flagging that, Ms. Keene.
All right. Oh, sorry.
I was just gonna say, Ms. Keene, I don't think your witnesses' names were on my list. So if someone could tell me the names of those witnesses too, then that'd be great.
I think she's having an audio issue, maybe.
It's
Kevin.
Sorry about that, John Igo and Kevin Hennessy. And then my co-counsel, Haben Goydam and Sarah Judkins.
Thank you.
Thank you.
Let's reconvene at 2:30. That give you what you need, Mr. Larson?
It does. Thank you, Mr. Chair.
Thanks. Ms. Keen?
Thank you, Chair. I just wanted to confirm to the extent that any issues regarding Mainspring's bid were discussed in the highly confidential portion after we stepped off, that we would have transcript access to those materials.
Yeah.
Great. Just want to clarify. Thank you very much.
Mr. Larson, redirect.
Yeah, thank you, Mr. Chair. This will be very brief. And it's going to be addressed towards Mr. Tom Janovic. You had a discussion earlier today with Commissioner Gilman about Rocky Mountain Arroyo and the treatment of the ITC under that particular CPCN. Do you recall that discussion?
Yes, I do. Justin Tom Janovic, Public Service, Colorado.
And can you just address, just to start off, what the treatment that was in that settlement that's been approved is with respect to the ITC?
Yeah, so in the approved settlement, just recalling what was there, is that what will take place is that the ITC will be received, like for the example of the let's say $100 million and a 30% ITC, it's actually going to be closer to 40% because it's an economic transition community. What would take place is that dollars would come in for that tax credit, and we'll be passing those benefits back to customers within the first 5 years of the life of the asset. So they'll get the 40% back, the tax credit, in the first 5 years.
And from an accounting perspective, are you able to take a tax credit received as a credit against plant?
No. So to the question of like the plant base, the rate base remains at the total amount. The company's not keeping those tax benefits. It's flowing it back over 5 years. And for US GAAP accounting and FERC accounting purposes, you can't take a credit from a tax and then take it as an offset to reducing your plant in service. So from those different accounting measures, we're not able to sort of lower and offset on the other end. So I just wanted to clarify what was occurred in that settlement that was approved by this commission a few months ago.
And is there, for the remaining projects that are taking the ITC, is there a proposal pending in the PIM proceeding, which is 24A-0441E?
Yes, there is.
With that, that's all that we had for redirect, Mr. Chair and Commissioners. Thank you.
Thank you so much to the panel. Greatly appreciate it. Ms. O'Neill. You hold up your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
You can put your hand down. Is anybody with you or communicating with you in any way?
You may hear my cat crying in the background, but other than that, no, nobody is here communicating with me.
With that one exception, if that changes, you'll let us know.
I will.
Mr. Kide.
Well, good afternoon, Ms. O'Neill.
Good afternoon.
Okay, standard questions. Can you state your name, spell it, tell us where you work, and what your position is?
Yes, my name is Erin O'Neill. First name is Erin, E-R-I-N. Last name O'Neill, O''N-E-I-L-L. And I am the Deputy Director of Fixed Utilities at the Colorado Public Utilities Commission.
Ms. O'Neill, did you cause to be filed in this proceeding what we're calling CEP delivery testimony, hearing exhibit 2709, both public and highly confidential versions?
Yes.
Okay, Mr. Chairman, Ms. O'Neill is available for questioning.
Ms. Keen, 15 minutes.
Hi, thank you very much. If we could please have hearing exhibit 2709 pulled up and jump to page 42. Thank you. If we could scan down to a little bit further so we could see the bottom of the page. Thank you very much. Ms. O'Neill, is it correct that in your testimony you stated generally that the Commission should order the extension of the life of the existing Alamosa combustion turbines, or CTs, rather than approve bid 11?
That was generally, yes, staff's testimony in this proceeding.
Thank you. Has staff's position on that point evolved since the submission of your testimony?
It has, and I do apologize. My cat literally is crying behind me. So if anybody can hear that, I'm sorry. It's not a baby, it's the cat. Yes, Ms. Keen, staff opinion after reading the extensive comments provided by Mainstream Energy staff's position on this has evolved somewhat.
And you be able to describe your current position on bid 11, please?
Yeah, so I think there was two things that staff sort of upon further reflection made us sort of revise our position a little bit. One is the company's sort of robust explanation about how Mainspring or this project is somewhat different as a Section 123 resource and sort of the additional consideration that should be afforded such a project. And then the other thing that staff sort of reflected upon further was a desire, which I think is consistent within all of staff's testimony, which is that we think consistency is important. And so to the extent that we are contemplating a process for other PPA projects and company-owned projects to, receive price relief, I think it makes more sense to us now to apply a similar consistent process to, bid 11, which is the Mainspring project.
Thank you. So to clarify, staff would not be opposed to the concept of price relief for bid 11, subject obviously to details, either being directed in this proceeding or in a subsequent CPCN proceeding. Is that fair?
I think that's fair. I mean, I think in our minds that the commission could consider this project as sort of something of a hybrid project, which is kind of eligible for component 1 and kind of eligible for component 2 as a clean energy resource, but also one that is, at least in the short term, intended to burn fossil fuels. And so, think, should the commission approve the IA process, we can see a reasonable path for the company or for Mainspring to get some relief through that process. But also believe that there are additional costs that are sort of outside of that process that need to be fully vetted in a CPCN proceeding. And in fairness to the company, I would like to Mainspring indicate that, staff does have some serious concerns about the price relief sought, but is, content to take that discussion and sort of fully vet those numbers and understanding of them through a CPCN process.
Great, thank you. And then just final question, or I think my final question, just to confirm, so staff is not recommending that in the decision in this proceeding that the commission order the extension of the existing Alamosa CTs at this time. Is that fair?
I think that's fair. I mean, it's our understanding that some capacity is needed at that particular location for reliability reasons, but that either of these would satisfy that, and that it's not a requirement to have both, which, might be interesting to examine the extension of these through some other venue, but that is not our current recommendation in this proceeding.
Great. Thank you very much, Ms. O'Neill. No further questions.
Thank you.
Thank you, Ms. Keen. Commission Counsel, any questions for Ms. O'Neill?
No questions. Thank you.
Commissioner Plant?
I have no questions.
Commissioner Gelman?
Hi, good afternoon, Ms. O'Neill.
Good afternoon, Commissioner.
Probably just one. Looking at the IA concept, as I discussed with public services witnesses, what do you conceive kind of staff's role could be, being that the IA, at least under their proposal, would primarily be managed by the company, but would also be evaluating company proposals for cost increases? I have some concerns to ensure that we can, first of all, set the right parameters for what would justify a price increase, and then on the actual evaluation of that. So, what role could or should staff play there to help ensure that that process as conceived would actually be an independent process?
Yeah, that's a good question. I mean, I guess I would maybe say two things. So one is just involvement, like literally just making sure that the meetings and scope of that, it has some review from us and comments, and the directive to the IA as to sort of what are the boundaries and what are they looking for is something that's been vetted by somebody besides just the company. So, and obviously that's, in this instance, that is staff. And the other thing that I would just like to clarify is sort of, we think about that IA process. I think the main underpinning, that we are worried about is vetting to make sure that the price relief sought is as a result of things that were not reasonably known at the time when the bid was provided. That this is not about just going back and getting a X% bid increase because everybody else is, but that there are actual drivers that can be established that are changed circumstances in the long time since these bids have been provided. And that's sort of why we're here, is sympathy that there has been a long time and a lot has moved in the world, but that we are concerned that to make sure that the price relief is tied to things that are legitimately changes in circumstance. That it's not a very specific answer, Commissioner. So, I think it is a good question, and other than the general showing up as part of that process, I'm not sure I have much more to offer.
No, that's helpful. I think I'm trying to figure out how through, if we pursue that process, how through some combination of, I think, the commission's directives here combined with staff and UCA involvement there, we got something that, is clearly focused on evaluating kind of unknown, unforeseeable price increases at the time of the bid. Okay, perfect. I didn't want to sign you up for it if you were not willing or able or had a conception how to be involved.
I would say there are many things in this process, Commissioner, that are not ideal. I think we all recognize that, and we are all in good faith trying to find a reasonable path forward and making the most out of a difficult situation. And so, yes, is this workload we all plan for? No. But is this extraordinarily important? Yes. And so, yes, staff is, again, we will show up for that conversation and that oversight.
Okay. I guess my only other question, kind of another somewhat general question, probably guess some of the points the chair was making. I have some significant concerns. We might be setting up a fairly long process, including for bidders who have not sought price relief or who have indicated they are prepared to move forward. Any specific advice or ideas on how we can ensure or incentivize bidders who have not looked for price increases to move forward, to do so in the most cost-effective way? Any thought?
Yeah, so I guess two thoughts, and then I might need to pause and think more. But one is that I think, as I understand the company's component one, stage one, if there's any bidder that is not seeking price relief, they can go forward right now without that. They would still be eligible for stage two price relief, but that if anybody is not seeking relief as part of stage one, they don't need to go to an IA process to re-verify a bid that was selected as part of the process. So anybody willing to stick with their bid can sort of opt out of stage one, and like that is already on a faster track. And then as regards stage two, as Mr. Eiley sort of explained, there's sort of, for the folks that do that opt out of stage one, they would still be eligible for upward price relief in stage two, but not be subject to downward price relief should something occur that would necessitate that. Whereas somebody who did participate in the stage one price relief process would run the risk of a symmetric up or down movement in stage two. It is not perfect, but it feels like that, with the combination of the IE oversight and sort of opening up the books and records to demonstrate the change in circumstance, it is a path forward, and it is a as reasonable as we have been able to come up with.
Yeah, I agree with you. Like a more expeditious path could be attractive, but we're sitting here 10 months after the original phase 2 decision and we have 0 contracts. So I don't know how expeditious we could actually hope for at this point to get these contracts signed. So I don't know, even any thoughts around how to incentivize or penalize, or like how do we get these contracts done, especially if the incentive is here's an expedited route, but we're already 10 months in and we've got nothing. What does expedited look like, or how would we get that to happen?
I'm thinking. I'm gonna have to think about that one a little bit.
All right. You can handle it in the SOP. I'm just trying to figure out like what's the carrot here. I mean, I'm seeing people willing to move forward with no price increase, and I don't even know what carrot we can offer them since this door has been flung wide open by this process. Expedited sounds good, but I'm so unclear what that even looks like. So anyway, if you come up with any ideas, let me know.
If I come up with any ideas,
Okay.
I'll put them in our SOP.
That's my only question.
I got one at the risk of being scolded by Mr. Dixon. I'm going to still throw it out there. I guess the problem, I mean, I could see how a bidder wouldn't agree to just move forward with no price increase because they lose the option to get up to a 6% price increase. So I think it's going to be really, I'm concerned it may be tough for bidders to want to do that. So see what you think of this alternative. Say we gave a uniform price increase of 1% to all solar plus storage, and standalone standalone storage bidders. I mean, we'll see what we get. And then we allowed the bidders who chose not to move forward to go through an IA process. But the goal of that IA process would be to agree on the lowest possible uniform rate increase to get each individual technology going. And then the bidders that move forward first would be eligible for that uniform price increase. What do you think of that, Ms. O'Neill? I think the idea is to somehow find a way to keep competitive tension in this. And I'm just worried project-specific increases are gonna not create a mechanism to reward the bidders who go first. So anyway, any thoughts on that idea?
So I have a couple thoughts. So one is I don't know if that's a material difference where if you give them a 1% price increase, that's enough for them to take that when there's still the option of a 6% out there. I'm not sure if that's a material change from where we are today, where they can move forward with no price increase.
Right. And I'm saying if there is, say, a uniform price increase for solar, the bidder that initially moved forward would get access to that that uniform price increase. So the biggest change is to create an incentive for bidders to go forward. You can call it no price increase, 1% price increase, but they would be eligible for a price increase if it was awarded to others.
So I guess the thing that I'm struggling with is feeling like I think staff and other parties tried to keep this process as close to what the commission has already approved in terms of the portfolio, in terms of the process for identifying and replacing a bid with a backup bid. And this process feels fundamentally different. Like we're throwing out pretty much the whole portfolio. And a bidder who is able to hold their price but is more expensive than one who wants a 2% movement, like that's not necessarily in the public interest. So just making our decisions about who moves forward based on who sticks with a bid when it may not be the one that's in our preferred portfolio, even if it's still in the backup, if that's a more expensive bid, that doesn't seem like the process that we should be trying to go with. And I'm not saying the process that we have presented here is perfect. Again, this is how we're staff, and I think other parties landed on where we are, is trying to keep as many of the pieces and the processes that we have in place alone. And so I don't know what that does. I don't know what that does. I don't know how much competitive pressure that actually applies when you have a limited pool of preferred and backup bids, and you're not actually evaluating them based on the level of cost of energy of those ones, but just which ones are willing to move forward with less of a difference from the original bid. It doesn't feel like it's a well thought through process to get to the best result in the public interest.
Aren't we way beyond? I mean, 18 months after the bids were submitted, we're looking at another 6 months of process where the pricing and the costs are changing every 30 days. I mean, aren't we way beyond trying to protect the, conform to some ideal process?
Yes, none of this is ideal. Nobody in this hearing would claim that the decisions in front of the commission are ideal or easy, right? This is a very difficult process to try to figure out how to get it back on track and get these projects moving. I guess I'm maybe more hesitant to change the process that the company's been contemplating and felt like works for them in their negotiation, in creating a process that it's not clear to me where that lands us and how much competitive pressure you're actually introducing as part of that. I'm not sure it's going to add very much, and so it feels like the process that's proposed by the company and that they're saying that they think they can implement feels like a more reasonable path forward.
Yeah, I mean, the difference is it would let a bunch of bids go forward now, when I think no bid's going to go forward, because who's going to pass up the opportunity for a higher price? So I think there's the concern is there's no incentive for anybody to go forward. So the entire bid pool is stuck for 6 months is the fear. Well, if you allow them to get some bump in price, depending on what happens to the other bidders who can't move forward, at least you get things moving without delay. And, so anyway, any further thoughts? And
no, I guess I would say, like, sort of in a way similar to the conversation I just had with Ms. Keene, and part of sort of staff's sort of shifting of opinions on mainspring, is really an issue of trying to stick to the competitive processes we have. And I realize that like, this isn't where anybody wants to be with this price relief. This isn't a process we have contemplated and we're all figuring it out. I think it's just been a hard conversation to try to keep to the approved portfolio to the best that we can, because that's what the company's been working on, and that's what bidders were communicated about, and that's where the good faith negotiations have been based around, is that portfolio and that process. And this process of an IA is an incremental movement in that, up to the 6%, and it's not ideal, but it's still based on the same underlying portfolio that the commission approved.
I guess, but it's totally insensitive to the fact that we're in a uncertain environment that changes every 30 days. And it's using a regulatory process in a world where the world is just moving quicker. So, all right, any other advice, comments?
I guess I had a couple things that I might comment on, if you would permit me. A little bit of leeway.
Why don't you want to just do it on redirect?
Sure.
Well, is it directly responsive to me?
No, not really.
All right. Mr. Kine, any redirect? I'd give you some latitude to ask a broad question.
So, Ms. O'Neill, on all the issues that we've been discussing today, do you have any additional advice or comments for the commission?
I have a couple. So one which kind of is actually directly responsive to you, Chairman, is I just want to orient folks to what may or may not be helpful to you all, which was that staff had provided an attachment, which is highly confidential ETO 5HC, which tried to provide a summary of all the information we know about all these bids and just which had failed, what the status of all of them were. And I think it's what we keep turning back to whenever there's a discussion of all of this, because for us, it kind of took all of the information and put it all in one place. We're not aware of any updates that have come out of this to that attachment. So just like, we would orient you to that just as informational, because we found it a very helpful summary of all of the bids, the status, what they were, what's failed, what hasn't, what was backed up, what was supplemental backup. Anyway, but there's a few things that have been discussed that I would comment on. So one which staff did not talk about in our testimony was the ISOC proposal. And I would just like to express some concern on this record in changing a tariff, which seems to have nothing to do with electric resource planning and selection of a portfolio, which is kind of the fundamental purpose of an ERP. And if the company wishes to file an advice letter to evaluate a tariff change to the ISOC and evaluate the value of additional capacity, staff would suggest that that's a more appropriate place to consider changes to the ISOC tariff. And then
you're pushing the boundaries.
I know.
Redirect.
I know. The other is similar, and if I pursue too far, I apologize, and you can cut me off. But on the discussion on the SCR, I do think staff is sympathetic to the substantial reduction in price that is represented by removal of that equipment. But we're also concerned that if in doing so, we lose some of the flexibility and the value of that project being able to dispatch, that's a problem. Staff's thought was not to necessarily, if the commission decides to go forward without an SCR, to move some of that discussion to the operational PIM, and that's a discussion about how that unit operates without the SCR that feels like could be addressed through that process, and that the company hasn't sought, and staff is not comfortable with saying they ought to get a 15% capacity factor assumption on that project on this record. I just think we have serious concerns that has not been vetted as a concept. And I apologize because I realize that also pushed the limits of what is redirect.
Any further redirect or not redirect, Mr. Kite?
No, those are all my questions, Mr. Chairman. Thank you.
Thank you, Ms. O'Neill. You may be excused.
Thank you.
Mr. Neal, can you hold up your right hand, sir? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
If that changes, is anybody communicating with you or with you in any way?
No.
If that changes, will you let us know?
Yes, of course.
Back to you, Mr. Dixon.
Thank you, Mr. Chairman. Mr. Neal, would you state your name and spell your name for the record?
Yes, my name is Chris Neal, CHRISNEIL.
And by whom are you employed?
The Office of Utility Consumer Advocate.
And what is your role with that office?
I'm a rate financial analyst.
And did you cause to be prepared what's been marked as confidential, well, highly confidential Exhibit 509 plus a public version of hearing Exhibit 509?
Yes, I did.
And if I were to ask you the questions contained in that document, would your answers be the same?
Yes, they would.
All right. Mr. Neal is available for cross-examination by Ms. Keene. Thank you.
Ms. Keene, 15 minutes.
Thank you very much. If we could pull up the public version of hearing Exhibit 509, please, and jump to page 21. Great, thank you. If we could scroll down so we can see lines 8 through 10, I'm a little below. Perfect, thank you very much. Mr. Neal, on lines 8 through 10, you state in regard to UCA's thermal alternative that the Plains End plant is again included, but this time as a purchase instead of a PPA. Some of the Plains End units can then be moved to the San Luis Valley to meet the capacity need there at a much lower cost than bid 11. Do I have that right?
Yes.
Would it be fair to characterize then UCA's position as being that the commission should direct public service to purchase Plains End and then move some of those units to San Luis Valley?
I think that is one of the options that should be evaluated. There needs to be more information, specifically the cost to move those units to the San Luis Valley and the cost to operate them in the same San Luis Valley.
Thank you. So to confirm, there's nothing in the record right now regarding what the cost to move or to operate those facilities in the San Luis Valley. Is that right?
That is correct.
Okay. And likewise, would you agree that there's nothing in the record regarding any reliability impacts that might be caused from moving some of these units out of their current location near the Denver metro area to the San Luis Valley?
That's correct.
And do you agree that it's possible that if there were some reliability impacts from moving those units, there could be transmission upgrades or some other sort of costs on the system that we don't currently know?
Well, I think if my proposal to put in 1,100 or 1,019 megawatts of capacity, much of it in the central Denver area, that would offset any impact of moving some units from Plains End.
Okay, but we haven't done that sort of specific technical analysis at this stage. Is that fair?
That's correct.
Thank you. And has UCA conducted any sort of analysis regarding the local emissions impact to Alamosa and the San Luis Valley of moving some of the Plains End units there?
No.
And are you aware of that information being anywhere else in the record?
No, I think the Plains End units would be cleaner than the current CTs at Alamosa, given the age of those CTs, however. So we see a reduction in emissions from the Plains End units.
But do you agree that they might be an increase in emissions as compared to building bid 11 there?
It could be, yes.
Okay. And are you aware that Alamosa is considered to be a disproportionately impacted community under state law standards?
Oh, yes.
And I know you're not an attorney, but are you generally familiar with the requirements imposed by Colorado Senate Bill 21-272, which directs the commission in exercising its regulatory authority to take account of and, where possible, help correct the historical inequities faced by disproportionately impacted communities?
Generally, yes.
And has UCA considered sort of any implications under that directive of SB 21-272 regarding moving the Plains End unit to Alamosa as compared to the potentially cleaner option of bid 11?
I think the primary concern was the capacity that needed to be provided there, and that's what our primary concern was.
So just to confirm, at this point, UCA has not considered sort of the specific impacts related to a disproportionately impacted community.
Oh, we did not consider the
moving Plains End versus bid 11.
We did not consider the emissions impact very significant at all, and therefore has little impact on the disproportionately impacted community.
Thank you. And to your knowledge, was there any bids submitted into the RFP in phase 2 of this proceeding associated with either purchasing or moving some of the Plains End units?
No.
And so your proposal is, recommending consideration of something that is outside of the bid process entirely?
Well, certainly purchasing Plains End was a new alternative brought in by public service. It was not submitted in the RFP, but that's a new issue. Moving the Plains End was something I identified because it was much less expensive than Mainspring.
But just to confirm, you say it's much, much less expensive, but we have not established the cost of purchasing, the cost of moving, the cost of any transmission upgrades, the cost of interconnection, any of those related costs. Those have not been established at this point.
That's not correct.
Is that correct?
We established a massive saving from purchasing Plains End. And the cost would seem to be much, much less than the very expensive cost of Mainspring.
Just so let me be more clear though, we have not established the specific costs associated with moving the Plains End facility or any of the associated costs that, secondary costs that might flow from that.
Those minor costs have not been established. We've established the cost of purchasing Plains End. You may not have seen that in the highly confidential information, but yes, we have a cost of
Fair enough. No, I know that it has been prepared. I was trying to direct you to specifically the cost with regard to moving them post-purchase. You also recognized in your testimony that you believe Plains End is a candidate for potential hydrogen conversion down the road. Is that correct?
I believe I noted that.
And the costs of potentially, sorry, let me start again. Is there any information in the record that you're aware of that estimate the cost of upgrading the Plains End facility to be able to run on hydrogen or hydrogen blend?
No, there's not. I just noted that would be a consideration for those who are concerned about acquiring gas-fired power plants.
Thank you. And the last couple of questions. Is there anything in the record that you're aware of sort of the technical feasibility of moving and installing Plains End units in the San Luis Valley?
Not that I'm aware of.
Okay. And likewise, anything in the record regarding what the interconnection process might look like for doing that?
Not that there's nothing in the record.
Great. That is all of my questions. Thank you, Mr. Neal.
Mr. Dixon, redirect.
Does the commissioners have any questions of Mr. Neal? I think usually I do redirect that to that.
Sorry. I do not have Commissioner Plant. Any questions for Mr. Neal?
I do not.
Commissioner Gilman.
Yeah, just a one repeat of my question with Miss O'Neill. That's funny. I just realized your names are very similar.
It's the Neal team, Chris and Aaron O.
With regard to potential involvement for UCA with the IA in terms of coming up with criteria, actually evaluating the proposals for price increases. So just any response as to what you would conceive UCA's role could be in that process, especially considering that public service would be involved in that process and is also one of the bidders that would be being evaluated.
My position is similar to Ms. O'Neill, that we would be involved. We would see the documents that the IA sees. We would see the justification for price increases, and we would be reviewing that along with the IA.
Great. And then probably just a repeat of the other question in terms of, we have bidders who are, it seems, willing to move forward with little to no increase, I guess I would phrase it. What, if any, incentives do we have to offer them to not participate in this process where they could get up to 6% price relief from? Can you think of any way for us to actually entice those bidders to move forward without that process?
That's a huge problem because they don't have any incentive. In fact, they've already been selected. So it's not like they're competing with lower prices anymore. They can all say they need the max price increase, and it seems like the IA is the only control over getting something less than that. I tried to create, just as Chairman Blank suggested, competitive tension. I said there are more projects in there that are quite a bit less expensive than public service selected. And I've got a big problem with public service not selecting the lowest cost bids and selecting selecting bids that are much higher than some of the projects they did not select. I've got tables in there, and the Arroyo 2 project and Rocky Mountain project that Piesco selected aren't on those tables. They're more expensive than all those projects in those tables. But Piesco took those projects and not lower cost projects. So I tried to say, well, look at some more of these, look at more projects to create competitive tension, and then take all their rebids and then reprice, reselect the projects that have the lowest cost bids, because that's one way to push those projects to only submit, the lowest price increase that they could, because otherwise there's no incentive for them not to ask for the maximum increase.
I'm with you in spirit, but given where we are in this process and a lot of people expressing really an urgency to get resources built in order to hit in-service dates for the system, how could a process like that work given the real significant time pressure here?
Oh, I don't think it takes any longer to talk to those other projects. They talked to the wind projects, but they didn't talk to the solar and solar plus storage projects. So I think those other projects could have been involved right now in the same way that all the other projects are. And they're only, they were like 6 or 8 of them. It wasn't like there were a massive number of new projects, but there are enough to create competition. But at the same time, Piesco needs lots of capacity. We've seen in the joint just transition solicitation. So it's not like we don't need more capacity. It's like Piesco needs capacity, and finding a few more projects to be considered is only helpful.
Great. Those are my only questions for you, Mr. Neal. Thank you.
Thank you.
I'll follow Commissioner Gilman's lead and ask my same question I asked Ms. O'Neill to you. What do you think if we sort of force the IA process to provide a uniform bid price increase by technology, and we made that price increase available to any project that moved ahead immediately? It seems like if we could get a bunch of projects moving ahead immediately, it would put pressure on the other bidders to be reasonable. Any thoughts about trying to do something like that?
I don't quite see how your proposal is going to work, because you say move ahead immediately, but then get a new price increase. If they're going to move ahead immediately, they don't get a price increase. So why would you then give them a price increase?
Out of a desire to treat everybody the same. And a desire to get them to move forward more quickly. And a desire to get out of this process as quickly as humanly possible.
I think if they're willing to move forward, they should move forward, and they don't need a price increase after that.
Yeah, well, the concern is nobody's going to move forward unless they're eligible for the same price increase everybody gets. So that's all I got. Mr. Dixon, redirect.
I have no redirect. Thank you.
Thank you, Mr. Neal.
Thank you.
Commissioner Plant, Commissioner Gilman, questions for the mainspring witnesses? Commissioner Plant?
I do not have any questions.
Commissioner Gilman?
No, I don't have any.
Geez, I have one question. Let me just swear you in for a second, Mr. Hennessy. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Igo?
Yes.
Is anyone communicating with you or with you in any way?
No. No.
If that changes, you'll let us know.
Yes, I will. Yep.
My only question is, what's the largest project Mainspring's done today, either under contract or operating?
The largest project that I'm aware of that's operating is a 10 megawatt microgrid in Southern California that's fully islanded. And so there is no grid power. It's a very high stakes application for Prologis to power their EV trucks when power was not available, which we believe is a pretty strong testament to the reliability of our technology.
And what's the largest one under contract?
I would have to double check on on that. We have other utility scale projects that we are in contracting on right now, but they're not contracted.
So this would be 5 times bigger than anything you've done?
I would say that much larger than any single project, but our current installed fleet is about 20 megawatts and growing. And it is the same technology for any single project. If it's a handful of units or if it's an array of 100 or more units, it's the same technology with which we have a lot of experience operating with high availability.
If Excel had offered you an offtake agreement, would you have signed it and owned and operated subject to an offtake agreement?
Forgive me, Commissioner. Do you mean if they offered a tolling arrangement with
yeah, tolling power purchase
of subject to the terms of that we would entertain that. The other projects we're in contracting on are tolling arrangements.
Okay. Yeah. That's all I got. Any redirect, Ms. King? You're muted.
Sorry about that. Real briefly, Mr. Ego, when you said that operating smaller projects versus larger projects is effectively the same technology, am I correct that that's because it's a modular nature? They're effectively in sort of isolated boxes, and so building one box, building 10 boxes, there's not really any difference in the operational profile. Do I have that correct?
Yeah, that's a fair characterization. May I elaborate a little bit on that?
Yeah, just realized it's getting late. So
yeah, it's a very scalable, like battery energy storage. So a smaller behind the meter project or microgrid similarly scales with an inverter-based grid interface, much like battery energy storage. So when you think about a main spring linear generator project, the topology and the scalability is very similar to battery energy storage, but we are not limited by charge duration or state of charge. The importance of which was discussed by Ms. Jackson earlier.
Thank you.
Thanks a lot. Greatly appreciate it. You guys can be excused. I guess Mr. Kruger. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Is anybody with you or communicating with you in any way?
No one is. I'm all alone.
If that changes, you'll let us know.
Absolutely.
Commissioner Plant, any questions?
Yeah, I just wanted to ask, similar to what I was discussing with public service, do you have any sense of the impact of tariffs on solar projects? And I know that they're all different and kind of depends on, a variety of different things. But if we're looking at, tariffs that may range from 20 to 60%, is there a certain amount of impact on the price of a project relative to those kinds of percentage increases? And if we're looking at a 15%, I think has been discussed as a sort of a cap here. Is that in line with sort of what you might expect in terms of an impact with those kinds of tariff potential changes?
Yeah, thank you, Commissioner. As you might imagine, the economics of every project is different and separate. Depends. You could have higher labor costs if you're further away from say a city center. You could have higher panel costs. Obviously, the panels will scale depending on the size of the project as well, and that'll have an impact. But I think it's fair to say that tariffs that have been already applied towards panels had they had a real impact on pricing, and threats of future because of the new administration, threats of future tariffs would also have a significant impact on the pricing of the PPAs and what would take to make a project go forward.
So there's not really any kind of calculation, 10% would have 3% impact on a total project or anything like that.
No, unfortunately, there's no uniform sliding scale like that.
lots and lots of things that will go into the costs of a project, and they will vary based upon the size of the project, the location of the project. Various suppliers have different agreements. If you have a domestic manufacturer agreement, if you're going to be purchasing foreign-made modules, there's a whole lot that goes into it, and there's not going to be a nice conversion, unfortunately. And I know that's what we're all looking for, but that doesn't exist.
Are there any actions that you know of that, some of the various different companies that do development that you work with are taking at this point to try and mitigate some of the potential cost increases? Are people trying to get orders in now? Or are they trying to get projects at least to an initiated point where they would qualify for various different things? Or
Certainly, lots of the developers were looking at the Biden tariffs and making sure they got them onshore. There was a utilization requirement that will almost certainly pass before most folks can use those. So those developers will have to use them on a different project somewhere else, not in our state. I think Tuesday's election results have everybody sort of spinning, trying to understand exactly, will President Trump follow through as he said on the campaign trail, or was that rhetoric that will be pared back once he hits, the governing side, not the campaigning side of things? So there certainly are actions that people are taking. I will say the lack of a signed PPA it hurts because you don't have any certainty that you're actually going to get to a project. So it's hard to go put a purchase order in with a manufacturer that's going to be binding because demand is greater than supply right now, at least domestically. And to not have a signed PPA, it takes a lot of courage for one to do that.
Great. Well, thank you. Mr. Chairman, I have no other questions.
Thank you, Commissioner Plant. Commissioner Govan.
I don't have any questions.
Mr. Kruger, in your comments, you referenced a prior red line PPA that you submitted in your RRR response. It sounds like some of those concerns were addressed subsequent to that filing by the company. In your view, are there any outstanding material contract terms that this commission should be aware of?
Chairman Blank, I'm not in the room, so we heard the commission, or sorry, Excel say earlier that they had resolved them. As the trade association, I represent the developers in this proceeding because they joined the association for the politics and the policy and the regulatory work that we do. We don't negotiate the PPAs. The testimony or the RRR that we put forward back in February was sourced from members who were extremely frustrated at the time. And I continue to hear frustrations about being able to get PPAs effectuated and signed. But I can't speak to any specific terms at this point, just because I'm not in the room and I'm not part of the PPA negotiations.
All right, so you're not bringing forward any specific item looking for help with. It's just generic concerns. Is that fair?
Yeah, I think, we need to get these things signed, and it does not appear to be a lot of, effort to adhere to the 18-month rule. So
I'll just ask you the same question I asked Ms. O'Neill and Mr. Neal. What do you think if we were to sort of allow the solar plus storage and standalone storage bids to move forward if people wanted, and then see if there was a uniform price increase that could be developed that those bidders would be eligible for, that might move this process more quickly. At least it would start getting contracts signed now. Given the concern that nobody's going to move forward and, give up the right to a potential 6% price increase.
Again, I'm not negotiating this as the winners are. I'm struggling to see how you would make this work. I think, again, there would be this incentive to kind of hang out and see if you could do better, unless there was some threat of losing the entire award. So, I think it'd be better on focusing on working with the, company to get some PPAs signed as, as we do now with some price relief and to move forward and not have a kind of a waiting game or a reverse auction style, solution here.
I'm not talking about that. I'm just saying if a bidder can move forward now, let them move forward. See if the company could figure out, based on the IA process, a uniform price increase, and then the bidders that had moved forward would be eligible for that uniform price increase. So every bidder would be treated the same in terms of a percentage increase. The difference is that would allow projects that are capable of moving forward now without giving up a potential price increase.
I think we'll have to address that in our statement of position. I could imagine I've got several members who have several different thoughts on how that would work. So
you'd be willing to, if you'd be willing to do that, that'd be really helpful. That's all I had. Any redirect?
I think just one. Thank you. Mr. Kruger, you were just talking to Chairman Blank about, whether there were specific terms that you could identify that are still persisting as being problematic for IPPs. And I just wanted to give you a chance also to weigh in on the specific terms that Public Service has put forward in this proceeding. Do you have any thoughts on those?
Yeah, thank you. As we saw in the highly confidential filing, the company has identified a couple of terms which were put forth by IPPs that they said that they couldn't agree to. And I think it's important to point out that's just one side of the story. Because those were marked highly confidential, I couldn't even share them with my members to get any sort of reaction to that. So sort of only hearing one side of the PPA discussion. As the commissioners know, PPA is a document that addresses risk, and a single clause out of context may or may not look applicable or even acceptable, but really it's the whole of the document that needs to be looked at here, and not just a single couple of examples pulled from a larger discussion from a document that really has a lot of give and take within it. So did want to make sure I got that in the record. Thank you, Jake, for reminding me.
Anything else, Mr. Schlesinger?
No further questions. Thank you.
Thank you, Mr. Kruger. Thanks for hanging out. I think that's it for the witnesses. Any comments, Ms. McLaughlin, Mr. Larson, any thoughts on where we are on statement of positions?
Yeah, apologies. I talked over you. Go ahead.
No, that was me. Go ahead, Mr. Larson.
Yeah, I think we talked about either the 15 or the 18 of November as a deadline. I mean, I think we could do November 15, a week from tomorrow, if that's acceptable to the commission, and if there's some kind of page limit, we could talk about that as well.
Does that work for the parties? November 15th, I think the idea was if we got them today, we do the 15th. If we got them tomorrow, it'd be the 18th. So I think we're done. So does the 15th work for people? Mr. Kind?
Well, Mr. Chairman, I think we have a preference for the 18th. Next week is a 4-day week with the state holiday on Monday, and everybody's extremely busy at staff, so any extra time would be appreciated, even if it was noon on Monday, something like that. So more time is certainly better from our perspective with how busy staff is these days.
Yeah, I could do see noon on Monday. Ms. McLaughlin, any thoughts?
No, I think that's acceptable. I think any later than the 18th would be pushing it though. So thank you.
And if any of the parties have any ideas about how to accelerate this or comments on the ones that came up at hearing, that'd be greatly appreciated. Mr. Larson, Ms. McLaughlin, any thoughts on page limits?
We could probably do 15. We could do 10 for parties, 15 for the company.
That seems short, but
I mean, The notion behind that is just, basically, I think, there's a lot of information that came out today. I think there's a lot of information already in the record. It's, really trying to get to the point so that we can have an actionable plan to move this forward, which is what a lot of the dialogue today has been about.
I'd say I'd appreciate shorter statements of position, but I don't know that I want to order them. Ms. McLaughlin, any thoughts?
I think that that's acceptable. There is a lot of information here to go over, but of course I'm thinking about what we need to read, and I know they're thinking about what they need to write. And of course we want to get to, a deliberation in short order. So 15 for the company and 10 for the parties, if the parties find that acceptable, works for advisors.
I'd go a little longer, Mr.
Yeah, from staff, I think the standard 30 pages is just fine. It's worked in so many proceedings over the years. I can pledge to you, Mr. Chairman and Commissioners, that we will exercise brevity wherever we can. I don't even know if I can write 30 in that amount of time, but I don't see any reason to handcuff people if they have something to say to the commission.
All right, I'm good with that. What's that Mark Twain quote? Sorry, I didn't have enough time to write a shorter letter.
It's great. We got the Grateful Dead and Mark Twain in the same hearing. All right.
Mr. Schlesinger.
Thank you, Mr. Chairman. I'm just communicating with folks on my team. I think that there's some confusion about exactly the proposal that you've put on the table through some of your questioning. We want to be responsive in our statement of position, but I'm wondering if it might be appropriate to ask that the commission issue an order, laying out the question and asking folks to respond specifically to the proposal, just so we're all making sure that we're responding to the same understanding.
I think we have to, Ms. McLaughlin, could you write up a brief order based on, so I guess it's almost like a bench order the three of us would do right now, because we can't wait till next Wednesday.
I was going to suggest, Chair, because we are going to work to get the transcript out, if you could summarize your proposal here so that then the parties understand a little bit better. And then that would be in the transcript. I think that might be helpful because, again, these are your statements and not necessarily things that your other commissioners have conferred on. So not necessarily an order. But I think that clarity, if your fellow commissioners agree that they'd like to get some responses to your proposal, would be probably helpful.
Here's the idea. That bidders who could move forward now for solar plus storage, and standalone storage would move forward now. Through the IA process, we try and develop a uniform price increase by technology, and any bidder that moved forward ahead of time would have access to that uniform price increase. And the idea is it would do two things. It would free up projects to move forward now without losing the potential for a future price increase. And it would give us real market information that would put pressure on the other bidders to be as reasonable as possible. So that's the idea. Mr. Schlesinger.
Yeah, may I just ask, I think I have two clarifying questions just to make sure that I've got it. The first one is, would the stage 2 still be in play? So up to a 15% stage 2 process as designed in the company's proposal?
Correct.
Okay. And then just to be clear, also under this proposal, there would not be a project by project IA review. It would just be by technology, and only bidders that aren't able to move forward would participate in that IA process?
Yeah, correct. And it could be project by project, but the end result would be a uniform price increase by technology, not a project by project increase.
And I'm sorry, I did just think of one other question. Would that technology by technology price increase apply to the company as well? Or is that dependent on the various pathways forward with the PIMS.
You can advise us on that.
Okay. Thank you.
Anything else before we close the record? Mr. Larson, Mr. Kine?
Yeah, Mr. Chairman, and apologies for the late hour. When we began the hearing, we had a discussion about the exhibits that have been stipulated to. So I'd like to make a record on that, just so everybody's clear in a transcript what is in the record.
Okay.
So if you'll indulge me for a moment. Okay. So hearing exhibit 2710, highly confidential, is the L&R table work paper that we discussed earlier. Hearing exhibit 2711, public and highly confidential, is the company's response to CPUC 56-3. There are a number of attachments to that discovery response, which are all highly confidential. There's attachment 56-3.A1, hearing exhibit 2712HC, 56-3A2, hearing exhibit 2713HC, 56-3A3, hearing exhibit 2714HC, 56-3.A4, hearing exhibit 2715HC, 56-3.A5, hearing exhibit 2716HC, 56-3B1, 2717HC, 56-3C1, 2718HC. That's the first one. Then just one more. The company's response to CPUC 56-4, hearing exhibit 2719, public and highly confidential versions. The attachments to that are highly confidential 56-4.A1, that's hearing exhibit 2720HC, 56-4A2, hearing exhibit 2721HC, 56-4A3, hearing exhibit 2722HC, 56-4.A4, hearing exhibit 2723HC. Now, I'll pause for a moment. Earlier in the day, we had a hearing exhibit 2724HC. We withdrew that from the box because it's a duplicate. And so there is no 2724. The final attachment's 56-4.C1, hearing exhibit 2725HC. And per Commission Counsel's request, for all highly confidential exhibits, we have provided a cover sheet. And for all highly confidential executables, we have provided a highly confidential PDF version of that executable. So I think that describes everything that we put in the box that I understand will become part of the record. And thank you for indulging me on a very lengthy record.
Thank you, Mr. Kide. Mr. Dixon, Mr. Larson, final matters.
Just from my perspective, Your Honor, I just want to confirm SOPs are due on November 18th by noon, and they have a 30-page limit.
Correct.
Thank you.
Mr. Larson.
The company has nothing further, Mr. Chair.
Mr. Schlesinger, did you have something?
I apologize, but one more question came up about your proposal that I'd like to clarify, if I might.
Yep.
Under your proposal, where certain bidders go forward and wait for the technology IA process, are you also including in that like I thought I had heard you say a 1% or 2% across the board increase, or was that a separate proposal?
I'm good either way. If a 1% increase helps, that'd be fine. Or if bidders can move forward without it, I'd look for guidance from the parties. So, but for purposes of this, why don't you say no price increase?
Okay, thank you.
Anything else? Well, just want to thank everybody for the great discussion today. we got a lot to think about, and appreciate it. Commissioner Plant, final thoughts?
No, just appreciate everybody's testimony and the streamlining and efficiency of the hearing. So thanks a lot.
Commissioner Gilman?
Appreciate everyone's participation, and I have no idea if this is the last 141 hearing, but it's been a long, strange ride, as was indicated.
Back to the Grateful Dead. With that, concludes the presentation of evidence. The record is closed and we are adjourned. Thanks, everyone.
Thank you.
Thank you.